Please be seated. The first case on the calendar for argument is Conrad versus Conrad, 788. Good morning.
Good morning. If it pleases the court, Rebecca Contz for the father. I'd just initially like to thank the court for their accommodations in the scheduling change. Now, if you can just keep Mr. Sarando brief, I'll be all set. As an initial matter, this is a case where, if you look at the record, what did the father really do wrong that deserved such a drastic change in both custody and visitation? I look at this record and I don't see anything that rises to that level.
Well, it seems like the court, to answer your question, would say that the father, what he did wrong, he involved the child in a lie about the mother's relationship with her former lawyer.
But when you look at how that whole issue came about. It was never really discussed in front of the child, so how did it impact the child? He brought it up to 3 counselors who have a privileged relationship, a confidential relationship. He wasn't screaming this from the mountaintops to any person who would listen to him. His attorney, who also has a privileged relationship with him, was brought into this. When the child recanted, it got dropped. He had an attorney representing him, so I can't say why the attorney didn't bring it up in the proceedings, but he had an attorney representing him. He wasn't saying this to any person who he could. When you look at how this came about, it was in a pretty contained situation. You have the reason why anything got filed was the mother clearly violated the judgment of divorce by flat out refusing to even discuss a change that was mandated in this judgment of divorce, that once the child hit full-time school, they were supposed to discuss this and change the schedule. She flat out refused. That's why he filed in the first place.
Well, it's clear, counsel, I'm on the video.
I see you.
Counsel, it was clear that once the child went to school, the schedule was going to have to change because of the timing. And the parties clearly were not able to work that out.
Correct, which is why the father filed. And throughout the hearing and the proceedings, people kept advocating for that the child needed as much time with his father, and that if you reduce the time that the child was going to have with their father, this would be a detriment to him. The attorney for the child zealously advocated that a reduced schedule was going to impact the child. And throughout the hearing, all the things that the mother brought up that were, the medical care, the child got all the shots. There was a disagreement about the timing of it. He didn't say no to shots.
So it sounds like your argument on appeal, you're not focusing on the custody situation.
I think
you're focusing on visitation.
I think taking joint custody was a step way too far in this matter.
We see a lot of these cases. I can't remember a recent case in a number of years where parties were more unable to get along and make decisions over medical issues, over schooling. These folks, that if he would call the police, they were arguing in the doctor's office. They were arguing, the father insisted on a sleep study. They go there, parties are fighting there, and they had
the sleep study. I think the sleep study was taken way out of proportion. The father noticed an issue. He asked for it to get looked into. The medical professional said, yes, let's do the sleep study.
About whether it was a good idea for the sleep study.
But they made it seem like it was dangerous to the child.
I'm talking about their inability to get along when the child was at the sleep study.
Yeah, the mother was berating him, saying that she didn't think it was necessary, and then as soon as the electrodes went on, she left. This could have been a very easy procedure for the child.
So you think they can co-parent?
I think when it comes down to it, they end up making decisions. The shots, it was decided without court intervention. The child is up to date on his shots. Yes, there is a reason why these two people are not married anymore. I totally agree. I also feel the first couple of years that two people are divorced, things don't always go great. But a lot of these tit for tat issues are kind of taken out of context. And when it comes down to it, there's this whole list of things that these parents have been able to decide. They decided on the remote learning, they decided on which church the child is going to attend, they decided on a pediatrician and a dentist. And when it comes down to it, yeah, there might be arguments because they have very different parenting styles, but he should still have a role in making these
I would just
decisions.
say
The
this.
mother continuously,
I would say
unilaterally,
this.
sorry.
If these parties, if we were to reverse here and say these parties should have joint custody, I can't imagine any two parents not having joint custody. But I think your stronger argument is on the visitation. He went from having almost 50-50, and now he has far, far less, so you might want to devote the
And
remainder of
the
your
court
argument to
went even beyond what was being requested. Had 2 uninterrupted weeks during the summer, and nobody even asked for that to be adjusted, and the court decided to cut that in half as well. And
Counselor, I agree with Justice Lindley. Even the child's therapist testified that the child was deeply affected if the visitation with the father would be reduced, and that the child was otherwise a very loving, sweet child who was thriving. So it seems to me that that's your best argument.
And 2 times during these proceedings, the father's visitation had been increased. And the school testified, the therapist testified that when the child was spending the 50-50 split, they had a 5-2-2-5. The child's some of the behavioral issues were alleviated, and the child was thriving under that arrangement, that they had agreed to the temporary schedule during these proceedings. And he was thriving, he was doing great. The attorney for the child said, yes, this is a great schedule. And then the court just slashed it. And I think that it was a great injustice.
All right, thank you very much.
Thank you.
Good morning. May it please the court, my name is Lisa DePola Haber. I represent the respondent mother, Susan Conrad, on this appeal. I will focus my comments on the issue of visitation, and I would like to address some of the issues that the AFC raised in her brief because I did not have the opportunity to do that in my brief. With regard to visitation, I would remind the court that the prior order was actually an agreement that was incorporated into the judgment of divorce. It did not include a 50-50 schedule. In fact, the schedule that was in the judgment of divorce that the parties had agreed to was very similar to what the family court ultimately ordered. That is, the father had every other weekend, he had 1 overnight during the week, and what was different is that at the time, the child was in preschool, so dad had the opportunity to provide daycare to the child in the afternoons.
He had 4 overnights every 2 weeks under my counting, under the agreement. Now, it did morph into more than that, it sounded like.
Yes, Your Honor. So it changed primarily as a result of the there was never a change in that order during the pendency of the lower court proceedings in terms of a formal order of the court being made. There was never a determination at any time that it was in the best interest of this child to have equal time with both parents whose relationship was vitriolic. That never happened. What happened was in February of 2020, when the parties appeared before the court on the proceedings, the judge directed, without having a hearing, that there be a change. And at that time, dad was given some additional time. It wasn't until the pandemic that dad actually got equal time. And that, at the time, was due to the pandemic and all of the concerns about transferring a child in school and everything that was happening at the time. That's when equal time started. When things started to calm down, mom wanted the schedule to go back to what it was. Dad didn't agree, and ultimately, mom was forced by the court to agree without a hearing to 50-50. So the 50-50 came only during the pendency of the hearing and only over the mother's objection. The therapist, the child's therapist, Megan Kennedy, testified at trial and direct examination that she thought that it would be negatively affect the child if the child had less time with dad. However, when pushed on cross-examination, she admitted that she couldn't say that as of the date of the testimony because she hadn't seen the child in many, many months. That is the only testimony in the record that would support the claim that less time with dad would negatively affect the father.
It seems what happened here is that the family court judge was angry at the father for his violations, for his behavior, understandably so. The court's decision was scathing with respect to the father's behavior, and I can understand why it would be. What the argument, though, is that you can't punish, that you can punish the father, but that shouldn't affect the child and the time that he spends with the father. And what the argument I get from the other side is the court changed visitation, reduced the father's visitation as a punishment for his violations of the prior order.
Respectfully, Your Honor, I would disagree. I would submit that the court reasoned and used the same justifications for the change in the parenting time schedule as it did for the change in custody. The evidence is overwhelming that the father's behavior with the child was not good for the child. The father had no rules. The father couldn't control the child. The child often, by the father's own admission, the child hit and kicked the father. And there were times when teachers and daycare providers had to help extricate the child from the father. The father created problems for the child that never existed. He called school and created a bullying problem, and he wanted to remove the child from his best friend.
Counselor.
He created medical problems.
Counselor.
Your Honor.
I'd be on the screen. Thanks. I hear what you're saying, but it's hard to get around the fact that regardless of why the schedule was changed as of March 2020, that's what the child became accustomed to. And beyond that, the child's own therapist said that it was going to be detrimental to the child when the father's time was reduced. And in fact, the child at one point was afraid that the father wasn't coming back, showing how important it was to the child. How do you respond to those things?
Again, Your Honor, I would emphasize that when pressed on cross-examination, the therapist could not say that as of the date of the trial, the date that she was testifying, that decreasing the time with dad would have a negative impact on the child. I would also submit, Your Honor, that it is the behavior of the father that caused the child to act negatively the way he did. The father failed to encourage the relationship between the mother and the child. The father affirmatively interfered with the relationship between the mother and the child.
Counselor, didn't the mother agree to end therapy so that the child would have that time with the father and not reduce time once kindergarten started?
She agreed to end therapy, Your Honor, but I believe my client's position was always that she didn't think that therapy was even necessary for the child, and that it was something that the father insisted on because he said that the child was having trouble adjusting to the divorce. But she did not agree that that was the case.
We understand your argument.
Thank you, Your Honor. I respectfully submit that the lower court meticulously analyzed every one of the best interest factors, and that its decision, even with respect to parenting time, is grounded in a sound and substantial basis, and that the entirety of the decision should therefore be affirmed. I would also point out, Your Honor, that the AFC asks for reversal of the determination as it relates to parenting time, but the AFC did not appeal and is not entitled to ask for affirmative relief. Thank you for your time.
Thank you. Ms. Bradshaw.
Yes, good morning, Your Honors. Arlene Bradshaw, attorney for the subject child. The court is really taking away my arguments because I stand before you with the argument. Well, I have two. My first argument is that the lower court was unjust in reducing my client's time with his father. This isn't about the father or the mother. This is about my client. And this child is very bonded with his father, and the records support the importance of this father in my client's life. Yes, did the lower court find that the father's behavior was, was poor? And I believe the lower court's decision on legal custody is appropriate because, again, as Justice said, that these parents cannot get along. They absolutely can't co-parent. But as I set forth in my brief, I believe legal custody deals with the relationship between the parents and how the parents deal with one another. Parenting time and physical custody has to do with the child's relationship with that parent. And here, my client's relationship with both his parents, quite frankly, is very strong. And again, the argument would be, Dad never wanted to take my client away from the mother. He just wanted to be in his son's life as much as the mother was. And since when that changed, my client's behavior changed. So this was a fairly young child, and so believe he did not know how to express himself when his mother would come to pick him up. So the way he expressed himself was throwing these fits. I don't believe it was a reflection on the father or the mother. The child just wanted to be more with the father, and we changed that. The child's behavior changed.
Are you advocating the child's wishes, or are you substituting judgment given the tender age of the child?
Well, quite frankly, I don't have to substitute judgment,
Would you agree
Your
with the
Honor,
child's
because
wishes?
my client has been very clear with me from the start. And I just saw him not too long ago in my office, and now this child is 8 years old, and this is not an unusual child. He's an extremely intelligent, articulate young man, and he understands more than probably a 6-year-old and clearly more than an 8-year-old. And he's very unhappy. He has a strong desire to spend more time with his father. And I think the restrictive amount of time that the lower court gave to this father is unjust. A week vacation in the summer? I don't care. Dad, I've been on this case and I represented this child since he was 3 years old. These are two really good parents. And it saddens me that I'm even before you today, because these are good parents, both of them. And my client has a right to have both of them in his life.
What do you propose would be the appropriate schedule?
Well, I believe it should go back to my client spending half his time with his father and half his time with his mother. And I think as set forth during the pandemic, that was what was happening. And this child...
That was before he was in school, and now they live 30 minutes away, but we understand it. The father should get more in your view, and
Yes.
we'll take a look at that.
Thank you, Your Honor.
Next case on the docket is 777, People versus Marquise Andrews.
Good morning, may it please the court. John Sarando on behalf of the appellant. On page 28, line 16 of our brief, it reads December 12th. It should be, I believe, October. And I would apologize for the mistyping. This is an appeal from a conviction for the crime of sexual abuse.
Mr. Sarando, I believe everybody is familiar with it. I'm particularly interested in point 3, which is the witness.
The witness, Miss Miss Primo.
Yes.
In a nutshell, the trial court improperly precluded her because the essence of the conversation of what the alleged victim related to this lady was the essence of the determination at the trial. And the cases that they relied on to not do it, Jones and Grayhaven and even Pavo from the Court of Appeals, when you look at the specific items in those cases, they were completely different than the going right to the heart of the matter. There's two ways that I think we can get over the hurdle. Either the trial court was incorrect, or unfortunately, he had two attorneys who didn't know the rules of evidence.
Well, it seems you have an A and B argument. If the court was correct in its ruling, and it's clear that it was a collateral matter and should have been, the victim should have been confronted first.
Right.
Then it's ineffective assistance of counsel for not doing that.
Right.
But if the court was wrong, which is what you're arguing, then the attorney, in deciding not to attack the victim over this prior false statement, it was an appropriate strategic decision to bring it in through Ms. Primo, and therefore not ineffective assistance, but that the court was wrong in precluding the witness.
I still think if I want to cross-examine you, if I want to bring in something that you said outside of court, I think the better avenue is to ask the witness, did they make the statement? I mean,
But it's
Mr.
not required.
Mr. Sarando? I'm
Yes,
on the
sure.
screen. Is there any difference between an offer to lie versus an actual lie?
that would have been the subject of the inquiry. That would have been the subject. I mean, she would have said it was the DA would say it's an offer, not an actual. But I think when you look at the fact that the other thing is getting back to the time, the long time periods, and it was just he said, she said, and it was just she said. I think that was the essence of the case, and I don't think you can say that it's. With all due respect, Your Honor, I think it's a stretch to say that it's a tactical thing, not to ask the question. I think it's really a tactical.
So you believe that it's an inconsistent statement, the fact that she offered to lie for some person about the very type of allegation in this case, you believe that is a collateral matter?
No.
Okay. You believe it goes to the heart of the controversy?
Yes.
Okay. And why would you have to, it would be like she says she's somewhere, you have a witness who says she isn't. You have to get her to admit that she say, but so-and-so says you weren't there. Oh no, I don't see it as an inconsistent statement. It's did she offer Ms. Primo to lie on her behalf, accuse someone of sexual misconduct? And Ms. Primo, who is not a friend of the defendant, who actually is associated or known by their children between the mother of the victim, said she's only met the defendant 2 times, and she's made it in a sworn statement to the police. You claim that should have been admitted.
Yeah.
We understand.
There's no two ways about it. I mean, when you look at the essence of the case, I think we've
And
covered
the time
everything.
frame is appropriate. It's all within 6 months
Yeah.
of the first allegation. The allegation, the offer she made to Primo, and the second allegation was in a 6-month time frame.
Yes.
Okay.
And I think we've covered everything else in our brief, and I don't want to get my associate mad at me.
Okay, thank you.
Oh, Judge Montour, it's good to see you.
You too, John. Thank you.
Good morning, Your Honor. It's Amy Hollenbeck on behalf of the people. In regard to the Ms. Primo issue, I think I've kind of laid out the people's position in my brief. Our position is that is collateral. First of all, there's no proof that she wasn't asked the question, so we don't know whether she had ever done that,
Wasn't it
not
just
done
really a
that.
credibility case, with respect to the victim, is whether or not she has the ability to represent certain facts and circumstances?
I think it's a credibility case as to the defendant completely. But she could lie about 10 other people, and it doesn't mean she's lying about the defendant. I'm exaggerating my argument here a little bit, but I think that's what reputation testimony is for, not specific instances of alleged lying. That's presuming it was that her offer to Ms. Primo involved a lie. We don't know that, but even if it did.
The judge's ruling, was that not that it was collateral or it was irrelevant. The judge said, I'm not allowing it because you, Mr. Defense Lawyer, did not ask the alleged victim about it on cross-examination. So that's what we're stuck with. Okay. Is that a proper ruling to say you can't bring in impeachment evidence without running it by the person who's being impeached?
To a non-material matter. This wasn't, if the allegation had been...
I'm struggling with the concept of a non-material matter.
I know. I mean, respectfully, I understand that.
On her testimony.
On her credibility. But if the statement had been, if Ms. Primo had said, I was with the victim and she told me the defendant never did this, we'd be having a whole different conversation here, because that would be material to the case before the jury. But I don't know where you draw that line. If she lied about somebody, if the
Well, it's
allegation
not
was she
something
lied
like-
about somebody doing something to her at school.
She lied
would that
about
be-
what school she was in, who cares?
Right.
That's truly collateral.
Right.
But here the question is, the only proof, and the proof of the conviction is she said this person sexually assaulted her.
Right.
She offered, according to Ms. Primo, to say, Ms. Primo, I'm friends with your daughter. I understand you're having trouble with your boyfriend. He's trying to throw you out of your house. I will falsely accuse him of touching me.
We assume that's what the statement was. There wasn't very much information
Well, there
provided.
wasn't information because the court.
We're
wouldn't
reading
allow
between
it.
the lines, but I read it pretty much the same way, Your Honor. I'm
Well,
not.
reading Ms. Primo's
Right.
two-page statement, she said she offered to
testify.
testify that this happened when it's clear it did not.
Right. Okay. If she's, yeah.
Look,
But
this
if
is
she's
the
not
problem.
under
Okay,
oath with
can I
Ms.
just-
Primo, or.
This is
This is
the problem.
collateral. This is
Well,
what I'm saying.
Is credibility on the key issue in a case.
Right.
Collateral. In the sexual abuse cases, as you know, it often comes down to, there's a delay in reporting many times. It's one person's word against another.
Right.
There's no DNA evidence anymore. There's no corroboration. It's one person's word against another. There's a lot of people doing time in prison based on the word of one person.
That's right.
So it would seem all the more important if that person's credibility is at issue and is allegedly offered to make a false claim under almost similar situations, to say that's not relevant or that's collateral, that doesn't seem like that would be a fair process here. We want to, if we're going to put somebody away on the word of one person, I think it would stand to reason that we should hear more about that person if he's made false accusations in a similar nature.
I would submit to the court respectfully that I disagree. That I can imagine, this happened in August of 2016. She alleges that one of the first instances here happened in the summer of 2016. She could, even if she was lying about offering to lie for Ms. Primo, how she knew to lie could be because she knew what happened to her. There are a lot of reasons that could
There's a
have
lot of
happened.
reasons that you could look at that go to the
Exactly.
credibility. It doesn't prove his innocence or anything, but doesn't the jury have the right to hear a similar issue in the same time frame, making the exact same allegation that was offered to someone who said it was false?
I would say not. And that is the purpose of reputation testimony. Because you don't bring witnesses in to say that the victim lied on a specific prior occasion about something not having to do with the factual pattern, the facts of this case.
I guess
They
that's
lied
where
about
we
something that happened to them a year earlier. They lied about something that it may be similar, but it's not the facts of this case, and that's what
Look,
reputation
it's a
testimony
close issue because we are mindful that we don't want to have trials within a trial.
Right.
You don't want to have people coming back and forth and litigating whether somebody lied when the main issue is elsewhere. So we understand that, but it's a tough issue, and we will take a close look at it.
Okay, thank you, Your Honor.
778 is People versus Jeremy Soto.
Morning. Catherine Menacot's appearing for Appellant Jeremy Soto. I'd like to start out by saying that the evidence before the trial court, I did not specifically characterize it as prosecutorial misconduct because I think a lot of what happened was not egregious in the sense that it was not meant to be misleading necessarily to the jury. Please interrupt me if you wish me to address anything in particular. But the result is the same. The jury heard evidence that was not properly before it. A lot of these inferences that the district attorney made in her argument were not based on the evidence before the court. Specifically, there was no evidence of the defendant appellant's possession of a second weapon, which I go into great detail, and yet he was convicted of both of those things. From the record
There's stronger
before,
evidence on the .38 caliber firearm than there is on the .22.
Well, I guess it depends on, the people argued that the defendant possessed the .38 because there was a spent shell in the revolver. There was no evidence argued by the prosecutor of possession of the .22. There was a cartridge, and I apologize, I referred to it as a bullet in my brief, but there was an unspent cartridge on the floor beneath the glove compartment, but both guns were found outside. Yes, it's true that the witness described the gun as a silver gun, and arguably the revolver is not silver, although that was not really made clear in the record as far as I can tell. She said it looked that way.
Counselor, isn't there an argument to be made that the prosecutor was linking together pieces of evidence and making argument and not vouching that that's what occurred?
Yes, there is an argument to be made that, but it still has to be based on the evidence. There was no one that could tie a second gun to the defendant, and I don't think, to answer your question, there's no clear evidence which gun was possessed by this defendant based upon the arguments made by the prosecutor. So given that, perhaps there's enough to show that there was possession of a gun, but it wasn't argued that way. It was specifically argued actual possession of both guns. The court charged constructive possession as to both guns, and so like in Diallo, which I cited, but I made an incorrect cite, and I apologize, on page 35. You're unable to tell whether the jury found him in actual possession or constructive possession. The people only argued actual possession. And given that the constructive possession would be circumstantial at best, defense counsel should have asked for a circumstantial evidence charge.
And counsel did not ask for the circumstantial evidence cause. And if one of the convictions stood solely on circumstantial evidence, that was an error.
Correct.
But there was direct evidence with respect to one gun.
A gun.
Because Ms. Torres identified the defendant as the person who she saw with a gun in the hand and fired it. But, so what would the defense lawyer have done here? Say, I want a circumstantial evidence charge on which of the two count, there was 4 counts, 2 relating to each gun. What would have been the request there?
Well, I think the error started way before that. It should have been argued before that there wasn't sufficient evidence as to 2 guns. Then it could have been flushed out which one the prosecutor was saying was possessed and which one was circumstantially possessed. You're right, that would have made a situation where he was arguing something that would not have made sense. He couldn't argue in front of the court. If he possessed one, he might have possessed one, but he didn't possess 2. So those errors started way before and left this situation where he could not properly argue that the defendant didn't possess both guns, but under the facts of this case as it was presented to this trial court, he failed to recognize those arguments, and failing to recognize that there was insufficient evidence with regard to a second gun.
So you're asking us to grant him a new trial because his lawyer was ineffective in failing to ask for a circumstantial charge?
No, I think that the totality of the errors by the court, the prosecutor, and the defense attorney here should result in a new trial.
But you don't suggest that the court should have sua sponte granted a circumstantial charge?
I do. I think under People v. Bryan, as I believe, some charges...
In Bryan, there was a request for the charge, and then the Court of Appeals found it harmless. So I understood your argument to be the defendant never asked for the charge, but the court should have on its own volition given the charge anyways, because it's such an important charge, almost like a mode of proceedings claim. And then you cited Bryan, and you cited another case, both Court of Appeals, where the defendants in those cases asked for the circumstantial charge. The court said no, the trial court said no, then the Court of Appeals said, yeah, you should have given it, but it was harmless. Those cases don't seem to support your position here that a sua sponte charge should have been given.
Well, I don't know what the other remedy would be here. It should have been given, and it wasn't. To blame one party versus another, some errors can be so egregious.
Right,
There's
so
no
I think-
direct evidence.
I think your argument would be, this is a mode of proceedings error, you don't have to object, you don't have to ask for it, it's so important. Or in the
Correct.
alternative, ask us to reach it in the interest of justice, that is unpreserved. And then third, counsel was ineffective in not asking for it. Those are the only 3 grounds I see.
That's what I meant to say. If I didn't make that clear, I agree with that assessment, and that was where I meant to go on that. With regard to other errors in this, I think the CPL 6025 error was also rose to the level that it should have been objected to by counsel. It was improper for the prosecutor to do that. There was no ruling from the court, as I pointed out. The witness did not testify that she could not presently or clearly say she could not presently identify the defendant. And to have the police officer testify to the identification under those circumstances was improper.
Thank you.
Thank you.
Good morning, Your Honor. Scott Miles on behalf of the people. Prosecutors are permitted to present evidence to the jury and ask them to draw rational inferences from that evidence, and that's precisely what happened in this case. The prosecutor at no point overstepped those bounds. All of the arguments that she made to the jury were rational inferences that could be made from the evidence that was presented. As far as the argument regarding the two guns, Justice Lindley, I believe you are correct that the evidence was much stronger in regards to the .38 caliber. The witness described the gun that the defendant had as a silver handgun and that he fired a single shot into the air.
What color was the .22?
It was, I believe it was black. It was a matte
So
black.
it's your theory, it's the people's theory in this case, that the gun that the defendant directly possessed and fired was the .38?
All the evidence points that way, Your Honor. Again, he fired a single shot into the air. The .38 caliber had a single spent shell in it. The .22 caliber did not have any spent shells in it. So it's pretty clear that that .22 was not the gun that was fired.
On the weight of the evidence issue, because he was convicted of possessing both.
Correct.
What is the, how is it beyond a reasonable doubt that he possessed the .22, which you just acknowledged that he didn't fire? There was another person in the car. The other person was driving the car. It wasn't the defendant's car. The gun wasn't found on the defendant. What's the evidence? I know there's some evidence there was a .22 casing at the feet.
Correct, Your Honor. So
is that beyond a reasonable doubt that he possessed both of them?
I believe it was not just the shell on the floor of the car. However, it was the fact that the two guns were both found directly next to the car. The shell that matched the .22 caliber bullet was on the floor of the passenger side, where all the witnesses were clear that the defendant was on the passenger side of the car. Taken all together, yes, Your Honor, I believe that that was proof beyond a reasonable doubt.
It's a lot closer than the .38, you would acknowledge.
I'm sorry, Your Honor?
It's a lot closer. The evidence is a lot leaner on the .22 than it is on the .38.
Certainly, I would of course phrase it that the evidence was much stronger for the .38. However, I would agree with that statement. In regards to the circumstantial evidence charge and the ineffective assistance argument, there is an argument to be made that not asking for the circumstantial evidence charge could be a strategic decision, a tactical decision. And the defendant has not established that not asking for that charge was not a deliberate tactical decision on the part of the defense attorney in this case. Unless there are any other questions, I'll rest my time. Thank you.
779, People versus Eddie Robles. Good afternoon. You are here on behalf of the people?
I am Caitlin Guptill on behalf of the people. I recognize my colleague has submitted this morning. Unless your honors have any questions, I will rest on my brief.
Thank you.
Thank you.
781, People versus Anthony Saccone.
Good morning, Your Honors.
Good morning.
Anthony Bellatier on behalf of the defendant, Mr. Anthony Saccone. May it please the court. I'd like to acknowledge at the outset that due to the tragic loss of life, this is an extremely difficult case for all concerned. I'm sure this court is no exception. I appreciate that. The issue that I'd like to focus on is the defendant's motion to withdraw his guilty plea. However, in order to set the context for that, I need to back up a little bit and explain a little bit about the facts of the case. This involved
I think
accident.
We're familiar with the facts, counsel, 3 deaths, speed.
Yes.
85 or 86 in a 35-mile-an-hour zone, and what his blood alcohol content was.
What his
And
blood-
then fled the scene.
Yes, well, I should comment on all those points which Your Honor brought up. One thing is the alcohol was the result of blood draw, which took place the next morning. There was evidence that was provided as Brady material that the defendant consumed alcohol after the incident. His mother gave a statement to the police that she found a bottle of liquor that was taken from the liquor cabinet, put on the dining room table, and half of it had been consumed. You might say that that's his mother, she would say anything, but that could have and should have been a subject for the jury. Now,
She did harbor him. I mean, she did hide him from the police. So why wouldn't we believe, that she might say anything?
she might say, it's her son. My only thing is that is a subject that a jury should be determining. Also, as far as fleeing the scene, the defendant was rendered unconscious as a result of the accident. He regained consciousness, he's disoriented, he's bleeding, and his car is on fire. The decision to go to his mother's house, which was only a short distance away, might not have just been to quote-unquote flee the scene, but to take care of his own medical situation. So again, it's ambiguous. There was no eyewitnesses. It was mostly a circumstantial case.
We're not dealing with the evidence. He pled to the charge.
He pled to the charge, but the circumstances of his guilty plea are significant. Number one, he's facing 3 counts of murder, which I have argued in my brief that was a gross overcharge because there was no evidence supporting the element of depraved indifference to human life.
86 miles an hour running a red light.
Excuse me, Your Honor.
86 miles an hour running a red light is not an depraved.
With a .18?
0.18, I mean, that's not an depraved indifference.
As far as
They could have been exposed during trial, and the jury found him guilty of that?
Well, you have to have some knowledge that you're endangering other people.
86 miles an hour through a red light, 1.8.
At 3 o'clock in the morning
86 miles
on
an
a
hour
winter
through a red
night
light.
in the middle of nowhere. The prosecutor himself acknowledged that it was unlikely for him to run into any other traffic at that time and at that location. However, as far as the light being
So
red,
it wasn't reckless in his mind?
was it reckless? I don't know. That is also a good question. He maintained that the light was green when he entered the intersection. There was a service ticket from DOT that particular light had been visited by a technician the day before. Now, was it functioning properly at the time of the incident? We don't know. That's a subject that could have been brought in at trial.
We're getting into the evidence that would have come out at trial, but what's the basis for withdrawing a plea on grounds of involuntariness? What's the specific argument that, because he knew all these facts, he decided to plead guilty anyways, what rendered his plea involuntary?
Okay, a combination of factors. Number one, at the time of the plea, at first he was at liberty, but he was arrested the weekend before the plea on a charge that was later dismissed for lack of evidence. So at the time, he's going from liberty to being incarcerated. The night before the guilty plea, unfortunately, his lawyer did not visit him till about 10 o'clock at night. And at 10 o'clock at night, the personnel in the jail said, you can only talk to him for 20 minutes. That is in the record. That is not the statement of the defendant. That is a statement of his counsel. So you have a triple homicide. You have all the rights that have to be explained in connection with the guilty plea. You have the rights regarding a waiver of appeal, and he had 20 minutes to talk that over with his lawyer. That's in the record. So also, clear and unequivocal assertion of evidence. That's at page 307 in the record. My client maintains he was not intoxicated, He was not driving recklessly. He had the green light. Each and every one of those points, you can debate it, but there's evidence in the record.
What about the
of that.
speed? Does he deny that excessive speed as well?
That is the only thing. He admits that he was speeding. He had a new car. He wanted to see what it could do. He was in a very open area late at night, and that was stupid, but it was not
How
depraved.
open could it be if there's a traffic light there?
Excuse me, Your Honor?
How open could that area be if there's a traffic light there?
Yes, there was a traffic light there.
Well, doesn't that
And-
go against your argument that?
Well, he says he had the green light. So he was speeding. He was guilty
Counselor,
of traffic violations.
Counselor, I'm on the screen. I'm on the video screen. I think you're missing her point. Her point is if it's an area that's a 35-mile-an-hour speed limit zone with a traffic control device, that's not an open area where you should be driving 86 miles an hour.
No, Your Honor, of course he should not. It was incredibly stupid on his part. My only argument is it's not depraved indifference to human life. It's not even necessarily reckless, and he had no idea that there were any other cars in the area. But also, let me point out that, excuse me.
I think your argument would be a little bit better if he pled to depraved indifference murder, but he didn't. He got a plea down, did he not?
He pled to aggravated vehicular homicide, which was the appropriate top charge, I'm arguing. But he specifically mentioned at the time when he was asking to withdraw his plea.
Your argument seems to be, well, he didn't commit depraved indifference because all these factors, but didn't plead to that.
No, he didn't plead to that, but having 3 counts of murder over your head certainly is a factor that has to be considered when you talk about his guilty plea, which he had 20 minutes to talk over with his lawyer, and that's on the record. Now, let me also say that part of this case was a full investigation of his movements before the accident, including videos of surveillance videos of his car. The prosecutor himself acknowledged that he was driving in a competent, safe, and law-abiding manner up until this one stupid decision to speed through this intersection. That's evidence that rebuts intoxication, that rebuts recklessness. And what I'm saying is, I cited the case of People versus McKennion. I'm saying that this person asserted his innocence. There's evidence in the record to support his claim of innocence, and it does nothing for the state of New York or anyone else to not let that be subjected to a jury trial. He's willing to face 3 counts of murder in order to have his day in court and prove his innocence. If the proof is so overwhelming, let him do that and let the people give him 25 to life. He's willing to do that. And now I'm hoping that he doesn't have to do that, because I'm also saying that I'm asking you to return it to the lower court without those murder counts, because I don't think they're supported. But even if he has to face 3 counts of murder, he is willing to do that because he is asserting his innocence. There's no good reason why that motion should have had at least been given a hearing so that more detail could go into the reasons why he pled guilty at that time. Thank you, Your Honor. That's my
Thank you. Mr. Taylor.
Good morning, Your Honors. Ken Tyler for the people. I'm not here to litigate the underlying facts because defendant pled guilty. What I would point you to, and I'm perfectly cognizant you're all aware, is this was an incredibly thorough plea allocution. The court confirmed defendant's answers 4, 5, 6 times.
What about the claim he only had 20 minutes to decide whether to take the plea? My understanding is that the plea offer had been outstanding long before that. Is that correct?
That's my reading of the record. I don't know that to be fair, I don't know that the record crystallizes exactly what the plea offer was before that day. It definitely reflects a plea offer was discussed between the district attorney and counsel. And at the time, defendant asked for more time. I need more time to consider this very serious plea offer. And just to be clear, I mean, this will be obvious to the panel, but it's not as if he got into this accident and he was unconscious and stumbled to the court and pled guilty. The case was pending for months. He had time to consider the plea offer. This was one of the more thorough.
But he only had 20 minutes allegedly to consult with his lawyer.
That may be. He didn't ask for more time. I view that as unpreserved. With respect to the claims that he was overcharged, in my mind, that's both barred and unpreserved. You can't challenge the legal sufficiency of the evidence after you've pled guilty. As you pointed out, he didn't plead guilty to those counts. Maybe that would have created a bit more of a connection in terms of the circumstances and how he felt about it. But what I'm going to rely on is the court is called upon. You look at these motions frequently. What you're often looking at is the plea colloquy and the apparent credibility of the bases for withdrawing the plea. They weren't credible here. The court correctly denied. Under the abuse of discretion standard that applies to plea withdrawal motions, the county court was correct.
Besides alcohol in his blood system, was there any other item in his blood that the test showed?
Cocaine.
Okay.
Cocaine. Cocaine, I think it was 0.14, maybe it was 0.18. Cocaine, 0.14, at least 84 miles an hour.
It was 0.14 when it was tested, but they extrapolated back, as they do, to the time of the accident. So it was 1.8 at the, it's not it's not relevant what it was when they tested it, it's the time of the accident.
Right. I mean, they're right. There's chemical reaction in the passage of time. He still had cocaine in his system hours later. For the reasons in my brief, I'd ask you to affirm.
Thank you.
Thank you.
784, Nowlin versus Cunningham.
Good morning, judges. May it please the court, Mark Schlechter on behalf of the parents, appellants in this matter, and I stress that I'm representing the parents because it's our position among the many arguments we make that the court did not properly consider the fact that we were dealing with a parent in this matter. We also argue that the court used the wrong standard in this modification proceeding and that there was insufficient evidence to support the violation finding. When it comes to the parents' rights, we argue that there was a real infringement on the parent rights. The court's aware that the law is pretty clear that courts are not to lightly intrude on family relationships against a fit parent's decisions because it's presumed that a fit parent's decision is in the child's best interest.
Counsel, let's go back a little bit. I mean, this is a somewhat unusual situation. We have parents that were teenagers when they, had this child, and they received a lot of support from both of their families along the way, including the grandparents who are involved here. So the closeness to their families, the fact that the child, when they were with the parents who were teenagers, lived with their parents, created a sort of different dynamic than we see typically.
Right. It absolutely true, and that was a factor. I mean, the mother was 15 when she gave birth. And the record reflects that for the first couple of years, she lived with her parents, and because of the age of the parents, I think the father was like 16, that the child did spend a significant amount of time, at least early on for the first few years, with both. But the record also reflects that over time, the mother moved away, had her own life, and the grandparents did have some contact. But it's interesting that you bring that up because in what we're talking about is an order that was issued in September of 2019 that was done on consent. The reason why the grandparents brought that proceeding back then was because they felt that they were not getting the visitation and the contact with the child. So the record reflects a period of time when the child wasn't spending that level of time with the grandparents, which is why they brought this proceeding. And interestingly, the record showed maybe 50, 60 photos in the record. All of them were from 5 years ago. So, we would submit that there really isn't anything in the record to reflect that the period of time prior to the September 2019 order, that the grandparents were getting that kind of level of visitation and contact that they were before, which is, again, the very reason why the proceeding was brought. And instead of reviewing this matter in terms of, we have a fit parent here, and there's nothing in the record to suggest that this mother wasn't anything other than a fit parent. In fact, some of the text messages reflect that even the grandmother said, you're a great mom. Instead of doing that, the court, without any real basis in the record, and I think even the attorney for the child suggests the inappropriateness of some of the comments from the bench, indicated that the mother wanted unfettered say, needed to dictate everything, expected everyone, including the court, to give her unbridled control, repeatedly threatened to suspend visitation. None of that was in the record, I would submit. And the court went even so far as to say that if I could, I would remove this child from your care and put the child with another
I agree.
parent.
That was overreach there, but just to break it down.
Sure.
You're not disputing that there were extraordinary circumstances here such that the grandparents had standing to get visitation. That hasn't been at issue, hasn't been challenged.
Well, if I may, Judge, the extraordinary circumstances would be applicable if they were looking for custody, but they were not. But to your point, I would concede that there was a relationship sufficient to give the grandparents standing to ask for visitation.
Right,
Correct.
So they had standing.
Yes.
Then you say no change of circumstances.
Correct.
Mr. Muldoon cites cases that say the fact that your client cross-petitioned for modification.
Right.
She wanted to change it too, the existing, because I know they had, the order was entered in September 4th of 2019. The mod petition came out 3 months later. Not a bad argument by you, but your client's in the same position, and we have case law, Birnbaum and Schaefer, that
Correct.
Mr. Muldoon cites, that says that issue is then waived. So we get over the change of circumstances, then we just get the best interest. This is a 15-year-old child. She's as old now as she was when her mother gave birth to her.
Right. And the irony was not lost on me, Judge.
So you're at a disadvantage in that there were two Lincoln hearing, I believe this is the case, you had two Lincoln hearing examinations of the child. You don't know what was said there, but we have a child who's older, and that may have weighed strongly in the judge's decision, and it may weigh strongly in our decision.
Right.
15 years old is of an age where the child's wishes are given a lot more weight.
Correct.
Than younger children.
Right.
So, and we know that the AFC is advocating for the grandparents to have it, so it therefore follows that the child wants to see the grandparents.
Okay.
I'm not disclosing anything that's in camera, but it's just a fact. He's advocating for grandparents to have the kid. He represents the child, therefore the child wants to spend time with their grandparents.
Right, I see, and I think, I hope the long enough question that I can give you three-part
It was
answer,
quite
right?
long. I apologize.
Okay. Number one, I will talk a little, just very briefly, the change of circumstances. I agree with the case law, obviously, it says what it says, but I would argue that the mother's petition, while it mentions a modification, I think it was more inartfully written. I think what she was really talking about was violations, and I don't believe that she requested in that petition anything other than a return to the September 2019.
She wanted restrictions, she wanted less.
Right, but
For the less time.
And she wanted control.
well, she wanted some control, but the order itself had given her some degree of control, certainly not the degree of control attributed to her by the judge. Secondly, when it comes to the wishes, again, I don't know what the child said, but I think we've all been involved in family court enough to know that when a child says, I'd like things to stay the way they are, it's sort of a way of saying, I really don't want to get involved in this. You know, and thirdly...
And you would say that's up for us to interpret.
Right, and we're not saying, we've never said that the child should never spend any time with the grandparents. So if the child is saying, I want to spend time with grandma and grandpa, we've never disputed that. We're just saying that under these circumstances, that there was simply not enough to do that. And when you mention...
enough of a change.
Not enough of a change to warrant what happened, because if you look at what happened, the court ended up giving the grandparents visitation that was befitting a non-custodial parent. 2 weekends of...
Well, they sort of were in that position, right? The father was basically out of the picture, lived in a different state, and in fact, the grandparents' visitation did sort of supplant their son's visitation.
Well, I would submit, Your Honor, that that's not what was reflected in the record. Again, that wasn't the kind of contact that they had. In fact, there wasn't anything in the record to indicate what that degree of contact. For example, to your point, if in fact the child was spending all that time with the grandparents, I would agree with that. But there's no showing that it was. And again, the whole reason why the grandparents brought the proceeding that led to the September 2019 consent order was precisely because they felt they were not getting enough time. And in September 2019, with the benefit of counsel, they agreed to a visitation schedule, which, by the way, was being followed. There was one incident when it wasn't. We admit that the grandparents didn't get an overnight, but they then got their overnight. And then every time the parties appeared in court, and the record reflects this, the first thing that was said was grandparents are getting their visitation. There was no issue to really resolve. It should have ended right then and there.
From my reading of the record, I think
Sure.
the issue that was involved here was that every time they tried to make these arrangements, it was getting more difficult and more contentious every time they made these arrangements, and the grandparents were trying to get something more definite so they didn't have to be in that difficult situation with the mother all the time.
Right, there are admittedly, of course, the record reflects that, I need to admit, there were communication issues, right? I think the communication issues, from the court's perspective, were attributed solely to the mother when they weren't. But to your point, yes, that there may have been some issues, but it had only been in existence for 3 months. So they did have some problems, but even with those problems, we had visitation happening, we had phone contact happening, there's phone logs in the record that reflect constant phone contact. And to your point, Justice Lindley, about the best interest, there's nothing in the record, there's nothing in that decision that says anything about the child's best interest. There's nothing to say that the grandparents, that more contact with the grandparents would be in the child's best interest. The grandparents' petition was really all about changing their minds. They didn't like what they agreed to 3 months before. And in fact, the grandfather specifically said that the reason why they brought the petition was because that order was not suitable to our needs.
Right, so you want us to reverse and reinstate the 2019 August stipulation where the grandparents got one night per month?
One night, because that is what they agreed to. That is what they agreed to. And I would put a second part. It would be
notwithstanding that the child may or may not want a lot more than that.
Yeah, I would submit that the child would be perfectly content with having contact with her grandparents. And again, we're not disputing that this grandchild should have contact with the grandparents. The extent of the contact is simply not supported. There's nothing in the record to talk about best interest. And to your point, Justice Lindley, not only am I requesting a remittal back to the family court, but I think it's essential that it goes to another judge. I think that the record simply here reflects that this judge has shown hostility, intolerance at the very least. I would argue that there's enough bias, even though that wasn't preserved, for this court to look at it in the interest of justice. But if not, I would implore this court that if the matter was to go back, that it needs to go to a different judge. This judge has already decided how he is going to rule, and in November of 2020, before the hearing even started, announced these grandparents are going to get visitation. It just depends on how much. That basically is pre-deciding the case before any testimony. So we believe that that this matter should go back to a different judge with some kind of a ruling here about how the judge employed the wrong standard in several areas.
Thank you very much. Mr. Muldoon.
May it please the court, Gary Muldoon for the child. Grandma, I can't explain in words how much I love you and thank you for all that you have done for me. That's said by a child who is 11 years old. Haley will be turning 15 next Monday. She is old enough and she wants to spend time with her grandparents. That's shown in the record, and it's quoted in my brief, and I also referenced the 2 Lincoln hearings. Normally there's just 1 Lincoln hearing at the end. Here there was one in February and in July.
So your client, you're saying, is satisfied with this order, which grants her Friday after school to Sunday evening, 1 weekend a month. If there's 5 weekends in a month, she gets 2.
Correct.
With the grandparents, and she wants that to continue, and that's what you're advocating for.
That is correct, Your Honor. Your Honor, a couple of things that I might note. First off, counsel referred to fitness of the parent. That is not an issue in this case. That's not an issue, really, in most cases, I think. The threshold issue of where equity would see fit to intervene, which I believe is in the statute, is not an issue in this case. I would note that there are actually 3 custody orders in this case. There was one from 2011 granting the grandparents visitation. Then there was an order from September of 2019 that quickly reached a violation and a modification petition. That earlier order on consent was a little bit what I called loosey-goosey. And I believe it says...
I haven't seen that term in briefs a lot.
Thank you.
You managed to work it in. So
Yes.
Congratulations.
I'll have to remember that. But it just is, it just needed to be clarified that they anticipated that this overnight visitation would be included. It was not actually established that there would be a visitation of an overnight. So there's problems with that order that almost anticipated that if there was going to be problems, that there would have to be some kind of clarification. One other issue that occurred in this case was the mother's, I would call, micromanaging. I don't think that when a grandparent is going to be picking up a child that they have to text the parent every time they stop in at a Burger King, which is essentially, it seemed to be what the mother was demanding. You must text me when and where you stop and almost start. That's a bit too much to ask of any grandparent, and the judge properly said in his new ruling that they don't have to say where they are within this 3-county area. So I think that the judges...
along those lines, what do you make of the second to last decretal paragraph of the August 26, 2001 order where Judge McAllister says that the mother, you can submit to the court reasonable rules concerning bedtime for visits, limits on cell phone usage, internet usage, etc. The court's going to review those rules and then determine which ones shall apply. It seems as though, I think the argument's being made is that the court's getting too involved in how the mother is raising the child, getting into the granular issues of screen time and so forth. Is that appropriate for a court to be getting that involved here?
Well, Your Honor, I read it a different way. I thought it was the judge, in a sense, after having made some rather harsh statements about the mother, reaching out to her, saying, if you want to have some kind of rules that we can accommodate, such as cell phone usage, which I think is an appropriate concern for a parent to decide. But I didn't read it in the way that it was he was getting too granular. He was recognizing that the mother is kind of hovering over this child a bit too much when she's in the appropriate care of two grandparents with whom she has obviously a very close relationship.
So those rules weren't meant to apply to the mother when she has the child in her own domain. Those were, the court was referring to, if you want to try to impose rules on the grandparents when the child is with them, then I have to approve, the judge, have to approve the rules for the grandparents, not in the mother's home. Is that
That was, yes, Your Honor, I'm completely, that was my understanding. Now, when it comes to the judge, the issue of recusal, or disqualification of the judge, I would first note that it was an unpreserved issue. I would second note that the judge did make some statements that are quite a dictum, that if the father comes back to the area, and he's out of state, he's now actually in Colorado in the Army, that the court would consider something else. I would note for the court that there is a new court proceeding pending involving the mother and the grandparents. It's pending now in court. And if there is an issue of recusal, it should be brought at this point properly preserved and raised. It does not need to be raised in this proceeding where it was this appellate proceeding where it was unpreserved.
What are the issues in this new proceeding, not to get too far adrift? But we always deal with this as is the appeal moot?
Right.
Because there's new proceedings that are going to supersede whatever we do here.
Actually, I think it would be fair for me to say that both counsel and I had discussed by email the idea of whether there was mootness, and neither of us believed that there was a mootness now. Actually, Your Honor, it is not moot in the sense that the new court proceedings, which I believe are cross petitions of some sort, has not been decided. There's been testimony taken, 3 days worth of testimony. The judge has made no decision in this case.
What's the issue?
I don't know. It has to do with modification or violation. Beyond that, I've not seen those petitions that have been filed that are before this same judge. Judge, I think it was Joseph Story who may have said that an overspeaking judge is no well-tuned cymbal. And I think the judge in this case did say make some statements that are inappropriate, but I do not believe that disqualification is appropriate in this case, particularly where it is unpreserved.
Mr. Muldoon?
Yes,
Mr.
Your Honor.
Muldoon, I'm on the screen. This would be the same judge that would have conducted any Lincoln hearings?
He conducted the 2 Lincoln hearings in February and July, yes.
So this judge is familiar with your clients?
Oh, yes, quite, yes, definitely. Thank you, Your Honor.
Thank you, Mr. Waldron.
Thank you. Yes.
785, Lori Oliveri versus Barnes and Noble, Inc. We are back for third time, second, we've been here a number of times on this case.
Yes, I believe it's probably the third or fourth time on this case, probably 4 times or maybe 3 times too many, but we are here. And I think I'll start, as the court has the contracts, it's read the briefs, and I'll basically, get to the minutia of the contractual arguments, which is, I think the main argument by the respondent here is, look, we just gave contractual indemnity to Barnes & Noble 2 months ago, case closed. But those agreements are not similar. In fact, they are very different in many material respects. And as the court knows, the agreement at issue here is my client agreed to indemnify NJS only if there was evidence that an act or omission of my client or the subcontractor that cleaned the floor caused the accident, okay? And counsel relies on agreement that has far more expansive language, and she harps on it again and again, but the problem is that agreement includes language that says it arises out of not only, it's that BNN agreed to, NJS agreed to indemnify BNN not only for all acts or omissions, but also on behalf, it agreed to indemnify BNN for all claims arising out of, or e.g. caused by, an act or omission, or based on, which is alleged acts or omissions. And I cited cases in my lead brief from the first, second, and third department, which show that those cases provided indemnity because as soon as plaintiff filed a complaint, he brought claims alleging that those acts caused the accident. My agreement doesn't say that. And to say that my agreement provides that kind of indemnity is a mistaken interpretation of that contract.
Your interpretation is that there's indemnity only if there's negligence or wrongdoing. We've already established, arguably, that there wasn't. But it seems like you're focusing on the first paragraph of the provision. Doesn't the second sentence, you focus on the first sentence. The second sentence seems to be rather probative as well. It says, the acts against which NJS is indemnified by RJS include but are no way limited to, and it goes through all these things: improper, defective use of materials or tools, inadequate supervision, failure to obtain necessary permits, registrations, license, all these things where there's wrongdoing or negligence.
Right.
Wouldn't that, couldn't that be read consistent with your argument that there's only indemnification if there's wrongdoing?
Correct.
But you didn't really argue that, you didn't focus your argument on that second sentence very much, didn't seem like.
No, I focused it initially in the lead brief on act or omission, right? And there was no evidence that my client or the subcontractor committed an act or omission that caused the accident, right? This court affirmed the decision that dismissed the complaint because plaintiff had no idea what caused her accident. She speculated and completely contradicted herself 3 times. But the language that controls is also at the beginning, the arising out of language, which my adversary believes is the functional equivalent of alleged, meaning that once plaintiff filed his complaint, ball game's over. But the cases she cited on that point are from decades ago, and they're outliers, because I cited case law in my reply brief, which shows that the arising out of language is not the functional equivalent of alleged. Arising out of in a contract means some causal relationship between the act or omission and the indemnity promise. But my client committed no act, no omission here because plaintiff never slipped on the stage due to any faulty contracting work by the contractor that we had clean the stage. And so that's why the indemnity agreement was never triggered here. Now, on the attorney's fees, the indemnification agreement specifically omits attorney's fees. And
we don't get to the fees if you're right on the first point, correct?
Correct. If the indemnification agreement is dismissed, the attorney's fees are irrelevant. But if we do get there, there's attorney's fees in another section of the agreement, which discuss only a breach of the contract. Now, a breach of a contract claim is a completely divorced and separate claim than an indemnification claim, right? The breach provision of the contract says a court determination needs to show that my client did something that they were supposed to do and didn't do in the contract. It talks about attorney's fees, but that agreement that clause not only does not refer back to the indemnification promise, the indemnification promise says nothing about attorney's fees.
It says litigation.
It does. And I understand that point, but I also cited case law in the reply, which show that there's a legal presumption. Case law from this court, from the Second Department, from the Court of Appeals, that says that the explicit words attorney's fees are not mentioned in the indemnity promise, then there's a legal presumption that attorney's fees are not to be awarded, okay? And so I think that law controls over over the other cases that seem to be outliers regarding the mention of lawsuits. And if we think about it too, if we think about the agreement in totality, right, it makes no sense that they put attorney's fees regarding the breach agreement, a breach of a contract agreement in a separate paragraph, and that they specifically excluded that language in the indemnity promise, and that they wanted attorney's fees to be covered by the indemnity promise, right? If attorney's fees are mentioned elsewhere, then you think they would have put it in their agreement regarding indemnity, but it's not there. So it actually cuts against their argument to refer to the other paragraph because the attorney's fees are actually explicitly mentioned regarding a completely different promise.
Well, doesn't the agreement explain that you have an obligation to defend?
The indemnity promise?
Yes.
Yes, it does.
All right. Haven't there cases been where the Boshnikov case explicitly says the general obligation to defend the indemnity provision is broad enough to encompass attorney's fees?
Sure.
Familiar with that case?
Yes, but that's also regarding the duty to defend is broader than the duty to indemnify. Is that what you're referring to?
They're included, yes.
Yes, but and that's fair. But I'm saying when you have a contract and you specifically put in attorney's fees regarding an unrelated promise, you're overtly saying, when the paragraph that specifically addresses attorney's indemnification promise, and you keep that out of there, you're making a promise. You're demonstrating your intent based on the entirety of the agreement that you don't want attorney's fees for that promise. And I'll close by saying, if attorney's fees are awarded, which I don't think they should be, I think the contractual indemnity claim should be dismissed, the attorney's fees claim should be dismissed, but they are limited, again, reading the whole agreement, to the underlying action only and the prosecution of the contribution claim, which they didn't move for summary judgment on. The contribution claim is dead to rights. Plaintiff's complaint is dismissed because there is no language in the agreement, again, regarding attorney's fees for prosecution or defense of a third-party indemnity action. And under Chappell and under the other case law that I cited in my brief from the First Department, it's the same analysis regarding attorney's fees. If you don't specifically put them in the agreement regarding the prosecution or the defense of an indemnification claim, you don't get them because it's against the general rule. Remember, we're operating under the general rule that attorney's fees are not warranted in these cases.
It would be, it seems, in the interest of justice, aside from the legal principles, it's rather harsh to have a party who did not engage in any negligence whatsoever to end up paying the fees for a lawsuit that was deemed to have no merit.
Right, and that's kind of the overarching theme.
If the parties are free to contract to provide for costs and fees in that situation, they're free to do it, but it does seem like a odd result.
It does, and I agree with you. I think that's the theme that kind of permeates the opening brief when I go through on pages 10 to 13 about, plaintiff brought a meritless lawsuit, and everybody from Barnes & Nobles to NJS to RJS to the contractor we hired, they cleaned the stage.
Now the question is, who has to pay for the fees to defend the meritless lawsuit?
And that's why we're here. But I will say, to your point, the arising out of language does not say what my adversary thinks it says. And I think if, relying on the Olivieri case that you decided in August, these agreements are not similar. Take a close look at them and you'll see the material differences, as I pointed out in my reply brief.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court. I'm here again on behalf of NJS, and as Justice Bannister may remember, I was here only a few short months ago making a very different argument regarding the arising out of language. And
A panel of this court rejected our argument, and that court's decision, that panel's decision in what we call Oliveri 2, is binding on this court and on this judicial department going forward. And in that case, the panel cited the Worth construction case, that arising out of means originating from, incident to, or having connection with. It doesn't mean a but-for or a substantial factor causal relationship. And there, the panel concluded that the plaintiff's action in this case had a connection with the agreement between Barnes & Noble and NJS because she alleged that the floor was in a dangerous condition. And that analysis applies exactly the same way here, because although counsel would like to make it sound as though the agreements are substantially different in the relevant portions, they are not. Claims or actions arising out of. That's the language that the panel in Oliveri 2 relied upon, and that language exists in this contract too.
Right. And even if there was a requirement for a finding of negligence, am I not mistaken, we're going back a while, but this court dismissed the plaintiff's claim in the underlying action against Barnes & Noble, not on the fact that there was no negligence by any of the subcontractors, the many subcontractors here, but it was a lack of notice to Barnes & Noble. They didn't have constructive notice of the dangerous condition. We never said there was no dangerous condition. Is that relevant here?
Well, Your Honor, it's somewhat relevant, but I would refer, Your Honor, back to Oliveri 2, where I believe the panel there may have interpreted it, the first Oliveri decision, a little bit differently when it dismissed the contribution and common law indemnification claims that Barnes & Noble had against NJS. There, the Oliveri 2 court, I think, interpreted Oliveri 1 as concluding that this court had determined there was a lack of negligence. But Your Honor referred to the equities in this case. I would respectfully submit that at least with respect to NJS and RJS, they cancel each other out. We're both parties who are being held liable to somebody further up the contractual chain in a case where the plaintiff's claim had absolutely no merit. And it respectfully gives me no pleasure to rely on Oliveri 2, but I believe that it is binding. The claims, actions, and arising out of language apply here just the same way.
I wasn't on Oliveri 2, I was on the first one.
Correct.
In the second one, the second sentence of the provision at issue in the contract, one that I read earlier, talks about the acts against which NJS is identified by RJS include, but are in no way limited to, and then it goes through a laundry list of things. You would probably want us to focus on the are in no way limited to phrase. But we have case law that says when you have a list of things, and then it says among others, the among others we're supposed to deem them to be in character with the listed items. We have all listed items showing malfeasance, negligence, suggesting that any other scenarios you can come up with would also have to be of that character.
Well, Your Honor, I would say that, I hope I say this clearly, the first sentence doesn't suggest that there's a requirement of negligence. There only has to be an act or omission. So I think that they're consistent in that they don't really match to begin with. All that's required is a claim or action arising out of an act or omission of RJS or its subcontractor. So, I mean, the first sentence doesn't require any negligence. So to the extent the second can be read too, I don't think it impacts the way that we need to read the first sentence under Oliveri 2. The argument that the agreement doesn't include attorney's fees. Your Honor cited the Boshnikov case, and I don't believe that a case from 2003 is too old for this court to rely on, particularly since it has not been overruled or even questioned by this court. But there, an agreement to indemnify from and against all claims or suits encompassed attorney's fees. And as Your Honor pointed out, particularly since the party there had agreed to defend. And here there is defense language. And I would also refer this court to the Lawson case that I believe the RJS cited in their brief, and that's a recent case from the Second Department in 2017. There, that court cited Boshnikov and said the result might have been different if there had been a duty to defend explicitly in the contract. So we urge this court to conclude that the use of the terms defend, actions, lawsuits, expenses under Boshnikov and all the other cases that we cite in our brief include attorney's fees. And to the extent RJS is making an ambiguity argument that is completely unpreserved, in fact, as we argue in our brief, their position before the Supreme Court was that the provision was clear and unambiguous. RJS's final argument, I think in order to make that argument, they literally have to change the words in our brief. And, you can't, or you shouldn't change defense to prosecute in order to make your argument. I mean, NJS is seeking indemnification and attorney's fees for the claim or action that we were forced to defend that arose out of RJS or TLC's actions. And that's the third-party complaint that Barnes & Noble brought against NJS. We submit that it's clear from our papers, and that the recovery of attorney's fees shouldn't be in any way limited.
Thank you very much. Case 786, Wilmot versus Keurig.
Good morning, Your Honor. Michael Rosenhaus for the defendant, Tony Keurig. May it please the court. There's just no basis for what the court below did in this case. There's no problem with the procedure followed by the county. Mr. Keurig did nothing wrong himself. He's purchased some land at a tax foreclosure sale. The idea that there was a violation of due process is simply wrong, as we discussed in our brief. There's a Court of Appeals case. There's no requirement in a tax foreclosure action under either the county's tax foreclosure law or the Constitution. No requirement to do a title search and send mailed notice to any party with an interest that shows up on a title search.
What about if, it sounds like under the Tax Act, there was no requirement to go over and above and do a title search. It sounds like the Monroe County's policy was, they nevertheless had a policy to do that. They hired Boylan Brown and then Boylan Code, and then they hired somebody else to do the search, and it was done, there was a mistake made with that process. So yes, there was no requirement under the Tax Act to do it, but I guess the argument is, once you voluntarily assume a duty, and you honor that duty to all the other foreclosed property owners, to do it here negligently may create a due process issue. It's kind of like, Good Samaritan. Somebody stops, you don't have a right to stop on the road to help somebody, but once you do and you drive them somewhere, you have the right to do it in a you have to do it in a non-negligent manner. That seems to be at play here.
That would be an argument, but there's no authority for such an argument. No authority, particularly when you keep in mind what we're dealing with. Mr. Keurig bought the property at a tax foreclosure sale. He had no knowledge of what happened. There was any negligence.
I agree.
It was not on his part. There may be a cause of action. This has kind of been a subplot, really, if you look at the briefs and the papers below.
Does plaintiff, even if what Justice Lindley is saying is true, was there any reliance by the Wilmots on, we know the procedure, and that's why we didn't file a notice with the county finance commissioner or something else, that they relied on the past practice?
Yeah, that's absolutely right. There's nothing in the record indicating that there was such reliance, and the idea that there may be a claim against the county based on negligence is not really before the court. I'm just here to protect Mr. Keurig and his interest in the property that he purchased on the foreclosure sale. And certainly, as between the Wilmots and Mr. Keurig, there's no rights created by what the county may or may not have done. I would add, just as a sidebar, and we pointed this out in the brief, the record actually is not entirely clear on what happened with the title search. There were statements by counsel that the an error was made in the title search, but what's missing is an actual statement of what happened by anybody at the title company. And to the extent that we have an affidavit and it attaches to title report, it does not support the facts as related by counsel, which is that according to the attorney, the title searcher found the right of first refusal and misconstrued it as something else. Well, if you look at the actual title search, they did not not actually find the right of first refusal. So
Because
it's
it wasn't
unclear
on
from
this
the
property.
Was
Was it recorded on this property or was it recorded elsewhere?
Well, based on the record, it looks like it was recorded on the property, but I'm just talking about the limited issue of the title search and the argument and allegation that there was a mistake made in the title search. Certainly by
I think
the...
they classified that as an out sale, didn't they?
Yes.
All right, so would that be a duty on your client then to, once they see the out sale, to investigate a little bit more? What does that mean? Not just disregard it?
I don't see where any duty arises against my client, the purchaser of the property. He bought it as a tax sale. He's willing to accept that there's a right of first refusal.
If you saw in the tax search that there was an out sale, is he responsible to do anything else?
No, I don't see why that created any duty on his part.
Your basic premise is that this is a dispute between the Wilmots and the Monroe County, that if there was an error made in the county's procedures, in the Tax Act, in the voluntary assumption to a title search, the Wilmots can sue the county for monetary damages. Your client, in your view, has clean hands. He hasn't done anything wrong. He bought it in good faith. He gets the property. Let them fight it out over their disputes.
Yes, Your Honor.
Thank you.
Any questions? Glad to answer. Thank you.
Mr. Ballard.
May it please the court, Todd Ballard, Harris Beach, representing the Wilmot family, Thomas Wilmot Sr., Thomas Wilmot Jr., and Loretta Conroy. Your Honor, this case is very, very well reasoned by Justice Martin. The facts aren't disputed. It's very simple. The Wilmots had purchased a portion of the Hunter farm, and they paid a premium. And in connection with that premium, they got a right of first refusal, which they properly recorded.
They filed it with they recorded it at Monroe County Clerk's office.
That's correct, Your Honor.
But it seems to be what the county is saying, they didn't file it on the chain of title. They filed it, but not in the right place, if I understand their argument. Am I misconstruing?
Yeah, that's a misconstrued argument. First of all, when you look at the record and the attached right of first refusal, there's a tax map designation, it was subdivided, and it was properly filed. Now, if we had a different title company here, quite frankly, it would have shown up in the county's regular course, and under the county's own procedures, the Wilmots would have gotten notice. It's that straightforward. So there are two innocent parties here, although I will say with respect to Mr. Carrick, he's saying that he's a good faith purchaser. That's what he says in his summary judgment motion. But in fact, the portion of our appeal, which hasn't been opposed by Mr. Carrick or the county, we're saying that there's an issue as to whether he is a good faith purchaser. Because in the underlying judgment of foreclosure, it says specifically that the purchasers take title subject to restrictions and agreements that are on record. There's no evidence here that Mr. Carrick, as a good faith purchaser, as he alleged, actually did his own title search. In fact, he said he relied on the county. So if he relied on what the county did, then I would say that a person with a recorded property interest would also rely on the county having a competent, skillful title search.
So you're saying before you go bid on property in foreclosure, especially of this nature, you have to do the due diligence and go down and check for yourself. They didn't do that.
They simply didn't do it. And if they did, then they could, under real property law, assert that I'm a good faith purchaser. I didn't find anything in the record. Therefore, any recorded interest as against this that's unrecorded, would not be enforceable against me. But here,
Millard,
yes, sir.
it seemed like Judge Martin placed heavy emphasis on a concession that the county attorneys made with respect to a mistake. It sounded like below, the county says, yes, we made a mistake. And if the mistake hadn't been made, the Wilmots would have been noticed. The county seems to be walking back that concession on appeal. Do you read their brief in the same way?
No, I don't. I mean, I guess there's two things. Under the County Tax Act, it specifically says you have a tax foreclosure attorney, which in this case is Mr. Costello from Boylan Code. Mr. Costello did not back off his position. He said in a sworn affidavit, not an affirmation, but a sworn affidavit, this is what happened, this is our procedure, and I think you have to get even deeper. There's an affidavit of regularity that's been filed by the county, by Mr. Franklin. And the affidavit of regularity at the Record on Appeal, page 416, basically says that the county, as part of their normal process, their interpretation of the County Tax Act, they retain a title company. And in this case, they retained a title company and it paid $180,000. And you would assume that if they're retaining the title company, that the title company would have performed this in a diligent manner, in a competent manner, and under their own procedures, the county would have provided everyone with recorded interest that's disclosed in the title policy notice. I think that it's be very difficult for us to ignore the importance of having notice, right? It's such a fundamental procedural due process right under federal law, under a state constitution, right? And I don't think any local law could say, hey, look, we're going to have a limited notice, which is notice by request, and any other notice, any other applicable law, we're not looking at it. And I would say that that interpretation is wrong.
And his property was special to the plaintiffs that adjoined their current property.
Yes, Your Honor, that's correct.
So you want us to have, you want the county to put it up for sale again, and the Wilmots bid on it, Keurig bids on it. I don't see any need to have anybody else bid on it, but
Correct.
just those two parties, and we'll have a bid off. Whoever pays the most gets it, and it's a huge windfall for these sisters who defaulted.
Exactly.
But you want the opportunity, you're not saying you're entitled to the property, your clients want the opportunity that they lost out on. And
Yes.
let me bid on it.
Yes.
And highest bidder takes it.
Yes. Your Honor, if the system had worked properly, the Hunters and the Wilmots, for generations, have known each other. If the Wilmots were aware that the Hunters had a very expensive piece of property, $400,000, and there's a $39,000 tax liability, if they had gotten notice of that, they would have, A, either redeemed it, or B, they would have worked with the Hunter sisters. I think what's very interesting here, though, is that real property tax law, 1125, would have required both regular mail to the Hunters and a certified mail. So I'm saying that if you look at the language under Section 2 of the Tax Act, it doesn't say that it's going to limit. It says there will be no limits, and it can't be limited by. So I think if you look under that specific section, Section 2 of the Tax Act, it's clear. It says the provisions of this act shall not limit or be limited by any existing remedy or procedure for enforcement or foreclosure of tax liens, but shall be in addition to such remedy or procedure. Such remedy or procedure. You need uniformity. You can't have the county of Monroe have one local law, and then the county of Seneca, the county of Onondaga, right, who respect, the basic federal, state, and then local law, but you have a state law that says that in light of Supreme Court decisions in this area, that you have to have adequate notice, right, tailor-made.
I agree with you on a policy level, but under the statute, RPTL 11042, does it not say that those provisions for notice in the state law, the RPTL, aren't applicable if the local municipality has their own notice laws, which is what happened here. So that's why we look, the argument is made that it's irrelevant, because I think your clients would have been entitled to notice under the state law, if I'm not mistaken. Under the local tax law, the argument is that they were not, which seems odd, that a local
Think about
government,
that.
like usually in federal and state constitution, the Constitution is the floor, the state can provide more rights but not less. Here the argument is the state provides one level of notice and the local governments can provide less. That doesn't seem to make sense, but that's what the law says.
Well, Your Honor, I think that First of all, 1104, there's been no arguments made by the county that they opted out. There's just been no arguments. But I think if you look at the rules of construction of the Tax Act under Section 33, right? Section 3 talks about existing rights and remedies preserved. So if I have a right to notice, a basic procedural due process right to notice before my property interest, recorded interest is taken away, then I have that. I have it under federal law, I have it under state law. Local law can't take that away. And then under Section 33 of the County Tax Act, Section 4, it says reference to other law and includes real property tax law. And it also includes CPLR, Civil Practice Law and Rules. With respect to that, under CPLR Section 2003, under that section alone, Judge Martin would have had a right to set aside a judicial sale. Why? For irregularities. Clearly, the record shows that there's irregularities here. We're not saying it's Mr. Carrick's fault, although he's not a good faith purchaser, although he alleged that. So as a good faith purchaser, if this was an improperly recorded property interest, he could have it as a defense. He doesn't have it here. And I think the court should also look at, there's been no argument on the cross appeal here. There's been concessions. They're like, you know what, Mr. Blard, you're right. Your client has an enforceable interest as against us. So when you look at that, right, that it's an enforceable interest and it's conceded, then how could you say that a local law can provide less notice than state or federal law? It just makes no sense. And I think that also under Section 33 of the County Tax Act, Section 9, it says effective other laws, such action in rem to foreclosure or tax lien shall be regulated by the provisions of the Civil Practice Law and Rules and by all other provisions of law applicable to foreclosure. My goodness, real property tax law is certainly applicable here.
All right. Thank you. We understand that. Appreciate it. Mr. Clark.
Good morning. May it please the court, Adam Clark for Monroe County. Just to address a couple of things that you mentioned, the county's not making an argument that the Wilmots filed in the wrong place. Rather, the Wilmots could have filed a notice
for request
for notice, and then they would have gotten notice of this sale. They didn't do that, and as the court pointed out, the county did have a different process, but there's nothing on this record to say that the plaintiffs relied on that process, that they had any idea of that process.
And my reading your brief seems to take a different tone than the arguments below. I read a concession there that there was mistakes made by the county through its agents, but for those mistakes, the Wilmots would have gotten notice. Therefore, you said to the judge, you don't need to reach the due process notice issue because we're conceding this issue, that they should have gotten notice. Now on appeal, you backtracked. Am I right?
No, we didn't intend to backtrack. We do very much concede that there was a mistake. And
By the county that cost the Wilmots the opportunity to bid on the property. You're saying the county agrees with the Wilmots on that?
Not entirely. We're saying there was a mistake that ordinarily the Wilmots would have gotten notice if there wasn't a mistake. We're saying that mistake is not, or the title search process is not something that's required by law. It's
so they made a mistake on a process that they gratuitously undertook.
Right.
But you did it for everybody else. All the other, like 1,000 other properties there. And didn't do it right for them, did it right for everybody else. And that's fair due process.
Well, that's sort of exactly the point, is all the other 1,000 properties, is that when we're doing something, when you're talking about something that we're doing gratuitously to try to make the best sale, mistakes are going to happen in all these 1,000. And there's a very simple, easy way for parties who are interested in a property, highly interested in the property because it's a neighboring property that they really want. There's a very simple, easy way to make sure that they are safe from those sorts of mistakes. But we're not walking back on the fact that there was a mistake There's a lot of arguments here that still seem to be attacking the constitutionality of the law, and we're saying that law is moot, or that question is moot, but we don't believe our law is unconstitutional.
So what do you want us to do? You want us to affirm it so there's going to be another sale?
I think that what should have happened, and this is sort of set up by procedural error in that plaintiffs moved to amend the complaint again to conform to the facts. And they didn't submit a proposed amended complaint, and then it was granted without that, and then there was never a proposed amended complaint. So we never had any chance to respond and say, let's work out a process where we can do this. But
should we remit it for that process to take place?
I think that could be an option. I think that also an option could be, as you said, the only two parties here that really need notice are these two parties. There's not really a reason for the county to hold that sale. Any referee could hold that
Right, your
sale.
brief, you keep saying they should work it out on their own, they should go to meetings. They tried that, it's not working. They can't work it out amongst themselves, they
Well,
tried.
the
So
court could order a
Your
sale.
solution, you need us, they need us, somebody in a row to resolve this. And I'm trying to get the county's position. Should there be another foreclosure sale, or should we just say Kirk wins and he gets it and the Wilmots can't even bid? Which one of those two is the county? What's your position?
Our position is that either way, a foreclosure sale can be held or another sale can be held with a court-ordered referee that's not the county. Because we don't have the authority.
Right, you can't do it unless somebody's defaulted on their taxes
Yeah,
paid.
we don't have a lien. So, and I mean, the court could make an order unwinding
We could
everything.
appoint a referee to do the sale,
Yeah.
and that's the county's position.
Well, we're not taking a position as to whether Couric should have the property or the Wilmot should have the property.
Well, it's not who has the property, it's do the Wilmots have a right to bid on it? And it sounds like you're saying yes, just not, you don't want the county being in the middle.
No, we're saying, we're not taking a position on whether they have the right to bid on it or not. We're taking a position on that if someone wants to bring a negligence action against the county because of a mistake, that makes sense. We know what to do with that. We don't know how to hold a sale that we don't have authority to hold.
Okay.
So whether or not there's a sale is up
And
to the
you don't have
court.
the authority to hold that because Couric has the property.
Right, and the hunters have the money, which
You have to
they're
claw
not even a
back.
party here, they're not here.
You have to get that back from them. It's a
Yeah.
mess procedurally, but not impossible. But, so your bottom line, because I know we kept you here long enough, but you can still concede the county made a mistake, that, but for their mistake, Wilmots would have had notice and the opportunity to bid. So how do we correct that? You proposing other things, you just don't want to, the county doesn't want to be the one to put it up for sale for various reasons, but you're not opposed to somebody else putting it up for sale, court-ordered sale. Is that accurate?
We're not opposed to that, yeah, but we're not taking a position on that. But we also, I think, are taking the position that the Wilmots had a better opportunity to get notice than just relying on.
But they're saying they didn't take all the steps to protect their interests that were
Right.
available.
In much the same way the Wilmots are alleging they didn't get a title search of, the Couric didn't get a title search of his own. The Wilmots could have done something more here, too.
I just have a question. It just appears that this is a very unusual situation where you have a tax lien of $39,000 and a huge surplusage afterwards, you know. And if the county was going to take any particular care with the way that they examined the title and the paperwork, this would be the case for them to do it right. I mean, it's a really unusual situation. You know, do you agree or disagree with that?
I don't know that the people who are doing the actual sale, I mean, it's somebody that the county contracts to do the sale, but I don't know that they look to every property and what its value is. I mean, this property hasn't been on the market in a long time, and I don't think that anyone realized what the value of this could be to certain parties.
Right, well, they certainly realized somebody bid, many times the tax lien to get the property, which makes it unusual in my background. I don't know, that, that there's so much money being thrown at this property.
It's a lot in comparison to the tax lien, but it's actually very little in comparison to what some of the parties are alleging that the property is actually worth.
Oh, and that's true. I mean,
I think it's something like there's so many different properties going on, and there are frequently properties where it's going to be bid up higher than that. But at the point where they're doing the title search, they don't realize that this is going to happen on a particular property, I think.
Thank you, Counselor. Case 787 is Florence Casket Company versus Vincent Iacovozzi.
Good morning, may it please the court. Michelle DiTralia for the defendant, Iacovozzi Funeral Home. I think the main point here is that insufficient evidence is no evidence. The plaintiff simply didn't meet its burden, which it bears on all issues, presented no testimony from any accountant, sorry, only hypothetical examples from its one witness. Credibility determinations are entitled to substantial deference, but here the lower court's only reference to any witness credibility was regarding those finance charges, which it then disallowed, which was proper. And that's important because this court can, after this non-jury trial, review the matter de novo, and there's really only one possible conclusion, which is that the defendant's motion at the close of the plaintiff's proof should have been granted, and the judgment herein needs to be vacated.
Well, Mr. Hogan testified, we have 18 caskets that we never got paid for. Hogan runs plaintiff's casket company. He explained this consignment process and how they got paid over the years, how they didn't get paid. How is his testimony, even if he doesn't have any invoices or receipts, which he does, how is that not, assuming he's telling the truth? He says, I sent 18 caskets over, I did not get paid for those. Then when your client, now I know you're saying it should be dismissed prior to that, but your client gets up in the stand, he has no explanation for any of this. His own records acknowledge he owed $22,000 plus. He was asked questions about, how do you explain this? Do you pay? No, I can't explain it. He had no answers whatsoever. If we get over the hurdle of the directed verdict, your client's evidence was a lot weaker than the plaintiff's evidence. But I guess you're saying we don't even get that far.
Yes.
But how isn't Hogan's testimony under oath, provided him these caskets, didn't get paid, here's my records showing he didn't get paid, how is that not enough at least to get it to the trier of fact?
Your Honor, I think there are some problems with Mr. Hogan's testimony, that he didn't testify to any dollar amounts. I know it's in the records, but when he testified, basically revealed that he was unaware of what the caskets cost. There were this funeral home also happened to have a fire. And there were 2 caskets that were in the building that Mr. Hogan went to look at and said, well, I'm going to take those back. I want to take them back. The elevator was, I don't know if it was destroyed by the fire or if it was, I believe it's not operational, I think is the bottom line though. And that he wasn't even aware of what the value of those caskets was. He gave hypothetical examples, used hypothetical dollar amounts. He didn't talk anything about dates. For example, the intermediate date for the prejudgment interest, there was no testimony about dates. It was only hypotheticals. There was nothing from the plaintiff's bookkeepers, anybody other than Mr. Hogan, who's demonstrated that he doesn't have the knowledge in his testimony, granted on other issues, but he's demonstrated that he isn't in a position to give this information to the court, which is the plaintiff's burden. And absent proof on that, again, the insufficient evidence is the same as no evidence, and the trial court, I think, overstepped and should have dismissed the case at the close of plaintiff's proof, barring that, it doesn't shift the burden to the defendant. The burden still remains with the plaintiff, and the plaintiff didn't meet that. They put in no proof that would allow the lower court to make any findings regarding what was owed. And in fact, under the defendant's expert's testimony, taking out the service charges and the fire damaged caskets, it ended up being that there would have been nothing owed. There was also a failure to ask whether there were any collateral sources. Does the plaintiff have coverage under its insurance policy for its property that's located elsewhere? And that wasn't explored. The facts don't support the finding of prejudgment interest. Again, that would be the plaintiff's burden, and they didn't meet that burden.
But you prevailed on that.
That's true, yes.
So that's not.
No, I'm sorry, no. The intermediate date was set in the judgment. There was I don't know the date off the top of my head.
You prevailed on interest charges.
Interest charges, thank you, Justice Niemeyer, yes. Sure. But the prejudgment interest was granted by the court, and the transcript's only 90 pages, and there's nothing in there about dates at all that would
Except the intermediate date that is in the judgment was after all the caskets were delivered and after payment had been asked for.
The court didn't.
If you look at the exhibits that were entered into evidence, which are before us.
Okay. But there was no, I guess I just don't think that the plaintiff put in enough to enable the court to make that determination. The court certainly didn't explain what it was doing. It just picked the day without saying where it came from, without the justification for it. And again, you understand my argument. The trial court was incorrect to deny the defendant's motion to dismiss. The defendant's expert, I think it's important to note that he testified that he did use not just the defendant's records, but he also used the plaintiff's records. And he explained all the reasons why he found them to be credible. And that's where he comes up with that $10,000 difference, which is the finance charges, which were properly disallowed, and then the 2 caskets that are essentially stuck in the building after that fire. And I think the court failed to give appropriate weight, or in fact any weight, to that testimony.
How were those two caskets that belonged to Hogan that got sent over there, then they got damaged, couldn't get out? How is not Hogan still entitled to be paid for those? It wasn't his fault the place got caught on fire and they couldn't get him out. I mean, how does that excuse your client from paying for them?
Because Mr. Hogan stated that he wanted to retrieve them. They were not, he personally inspected them, I believe. And my understanding from reading, again, it's only 90 pages, a short transcript, but my understanding from reading the trial transcript was that Mr. Hogan viewed the caskets, and his testimony was that he would take them back.
But it's impossible due to the fire that was beyond his control.
On the date of the trial, but that could change. I mean, it's not forever, it's not permanent. There wouldn't permanently be no power, there wouldn't permanently be no ability to get them out, and if he wants to get them out, he can certainly take steps to do that.
There was damage on the interior as well to them. This is what his testimony was.
Correct, but he did say that he wanted them back, so if he wants them back, he certainly can't double dip.
Okay, thank you.
Thank you.
Good morning, Your Honors. Excuse me, Carl Mann, appearing for Florence Casket. May it please the court, I would respectfully submit that this is a very basic collections case, and I'm surprised that it's gotten this far. The plaintiff made out a prima facie case at trial through the testimony of its CEO and through the documentary evidence. Part of the record includes invoices for each and every casket that was delivered and allegedly not paid for, a complete record of all payments that were made, which was by the defendant, and none of those records were factually disputed by the defendant. So I don't know how counsel can argue that there was not a prima facie case. I mean, how much clearer could it be? The defendant called an expert to try to rebut that, but he didn't rebut it with any facts that were recognizable. He talked about accounting issues, but he didn't actually present any evidence to rebut the plaintiff's case that caskets were delivered, caskets weren't paid for. frankly, I believe if anyone has an appeal issue here, though we're not raising it, didn't raise it, it would be the plaintiff, because on the issue of the finance charges and the issue of an account stated, I think the record does support an account stated. The judge denied that. I think the record.
At this point, you're just asking us to affirm the judge.
That's all we're asking for is an affirmation. Frankly, my client will be happy to collect on the judgment. But I think if we were to really get into the nitty-gritty, I think all of the court's rulings actually benefited, that were close calls, so to speak, benefited the defendant, not the plaintiff. On the account stated issue, the denial of service charges at the 1%, and the intermediate date that was chosen was 2016, when the last casket had been delivered in 2014. So I don't really recognize or see how that's an intermediate date at all. That's a 2 years later date. Intermediate would have been somewhere between the date of the first casket that's unpaid for being delivered and the date of the last casket that had been delivered. So I respectfully submit, Your Honor, that certainly a prima facie case was made. The defendant's motion to dismiss the conclusion of the case in chief was properly denied, and that the record supports the judgment of the lower court.
Thank you, counsel.
Thank you.
790, Mosley versus Parnell.
I think you're over here. Thanks. Good morning, Your Honors. Mike Bersani for the plaintiffs. Your Honors, I'd like to first clarify again, like I did in my brief, what we are not claiming, because the defense claims we're claiming things we're not claiming. We're not claiming that we have a right to occupy or possess this 20-foot right-of-way that leads to the lake. Okay? All we're claiming is very simple. There's a long tradition of a temporary seasonal dock, and we want to have a right to continue with that tradition. That's all we're claiming.
You rely on Horst and the Hush versus Taylor and the Hinckley case, which seem to be similar fact patterns, where it was held that when you have a use that's reasonably incidental to the access, then that's permissible. In those cases, it was docks. Here, it's a dock. We don't need to get to the grantor's intent. The grantor is not around anymore.
Exactly.
Having further discovery is not going to bear fruit on that issue. This document speaks for itself. It's just really, is it reasonable use, incidental, to put a dock in there? You rely on Horst and these cases that he doesn't try to distinguish, so we should follow our decision in Horst.
Yes, Your Honor, I'd like to put one thing about the Holtz case. In the Holtz case, each plaintiff, it was a subdivision case, and each plaintiff was awarded a right to their own dock. What we're claiming is much more modest.
You have a community dock.
We're claiming one common dock, the same as in the Briggs versus Dodonna case, third part, almost exactly on point. It was they called it a common dock. There were several subdivision lot owners that wanted one single dock amongst them. And there was a long history of the dock. They proved it like we did with photographs and with testimony that it had been there for a very long time. And in that case, the court awarded the plaintiff exactly what we're claiming here. And I want to point out there's really three things that show the grantor's intent here. One is the actual language. The 1931 deed that created this right-of-way says very broadly that it is for the benefit of or for all 22 lot owners. Some of those lot owners have their own lakefront. So clearly this is kind of like a place where everyone can mingle and enjoy the lake. Secondly, in that same deed, there's another right-of-way that's described, very limited. It says pass and repass for vehicles. That one had limiting language. This one didn't, and it led to a lake. So those are the two things. The third thing is the history itself, and I put in a photograph from Cornell University's wonderful website that shows a picture, an aerial of the dock in 1954 in that right-of-way. And that photograph. That's only 23 years after the right-of-way was created. Now remember, at that time, the creator of the right-of-way, the Bowen Products Corporation, still owned the fee interest in that right-of-way. And they owned it until 1977. During all that time, there was a dock there. This shows the grantor's intent was to have a dock there. In fact, I've got testimony from a non-party witness, Ms. Mitchell, who lived in the area in the early 70s, before 1977, and said even then, when she moved in there, there was already a long history of the dock being there. So we have to show, I'm going to make this pretty simple, we have to show, according to all the case law, that the dock is a reasonable use, incidental to the purpose of the right-of-way, which is enjoyment of the lake. We think we've shown that abundantly. And what does the defense do? They try to shift my burden to say that we have to show that the dock is necessary to access the lake. That's what they argue in their brief. Just like they misstated our claim, they're also misstating the law. We don't have to show it's necessary. We have to show that it enhances the purpose, which is enjoyment for this community. And with that, Your Honors, unless you have any further questions, I'm going to sit down and let my opponent speak.
Good morning, Your Honors.
Good morning.
I have great respect for Mr. Bersani. I think we get along very well. But did you catch it? Did you catch it when he told you that I'm misstating what his argument is? And did you catch it when he said his argument? There are two things he just said in oral argument, and it's a line that he keeps trying to skirt, and it's not an easy line for him to skirt. It's problematic here. He just said the Bowen Products Company, right, number one, when they were doing the deed conveyance, intended an area where, and I quote, everyone could mingle and enjoy the lake. That's not access, that's occupancy. That's not going into the lake to launch your boat or coming down to the lake in the winter to get ice for your ice box in the 1930s. That's not what we're doing. And this is continually what's happening. They want a right to occupy the shoreline of my client's property. They want a right to do whatever they want there within this little 20-foot strip that needs to remain open so boats can launch. And the other thing he said, again, trying to characterize that I'm mischaracterizing his argument, he said that when Bowen Products had this property through 1977, they let a dock there. They permitted a dock there. And the cases that we've cited note that in situations of neighborly accommodation, which is what was happening here, you don't have the kind of thing necessary for, say, an adverse possession claim. Now, as to Hush and Holst and that line of cases, of course we're aware of that line of cases, but I want you to take a look at what we're doing here. Take a look at the easement. The photograph, in particular the one that I would refer to as the photograph with the obscene gesture, that's in the record at 357. If you look at that photograph, that's a shot up the right-of-way area. And that photograph in the record shows that in the entrance to the right-of-way, we're really dealing with kind of a driveway that then fans out into my client's property, the north end of my client's property. And they've got a dock right in the middle of that accessway. Well, if you're putting a dock right in the middle of that accessway, then it becomes more difficult for owners that have boats to back their boat down and launch it. And some of that's topography. I can't change the fact that there's kind of a narrow approach on this easement. So I do have concerns about this. I will note that especially in the Hush case, we were dealing with a 60-foot right-of-way. And the right-of-way was the whole lot. That was it. In Hush, grantor had reserved 2 lots. There's a question over one of these lots, but it was 60 feet wide. There was plenty of space. There's not necessarily that level of space here. The other interesting thing that Mr. Bersani referenced was he said, look, I submitted this affidavit of Barbara Mitchell. Barbara Mitchell used to be there, and Barbara Mitchell will tell you a dock was always there. That's the record 279 and 280. That's Barbara Mitchell's affidavit. And what does Barbara Mitchell have to say about this? She has to say, well, at one point, a prior owner of Mr. Weber's dock, or excuse me, the lot that my client, Mary Ann Parnell, owns, thought to mount a challenge and then allowed it to remain, permitted the dock to remain. That, again, is permission. All this is related to the prescriptive easement. What I would submit to you at this stage, the court correctly allowed for depositions to occur. We've had some depositions to occur. It's beyond the record, so I can't get into that at this point. But we've had some depositions on the record. I certainly understand why Mr. Bersani didn't want depositions on the record.
Mr. Bersani says that any depositions would be relevant to the second cause of action for the prescriptive easement, but on his first cause of action, what evidence would come to light regarding the intent of the grantor here?
Well, so the clearest intent of the grantor is the right-of-way language. I cited that in our brief in the boxes. I had a comparison of Mr. Bersani's desire to establish a public beach versus the actual language that was
So there's
used.
no discovery on that. We don't need any discovery. It speaks for itself.
Well, the language speaks for itself, that's right. And so then we get into the question of, okay, is it reasonable? Actually, two prongs. Is it reasonable and is it legal? Now, Mr. Bersani is presuming it's legal. He hasn't submitted any town code or anything or any analysis on that level. But set that aside for a moment. The question is it reasonable? And therein lies the problem. Because of this particular easement and its layout and its topography, what do you do when one owner out of 22 wants to put a dock in the middle of this easement? And make no mistake, this isn't a situation where all of the easement holders are united in interest or united in their understanding. Now, there's a number of them, obviously, that are under the banner of the plaintiff here, Mr. Mosley, the lead plaintiff, who seems to be the ringleader here. But they sued Howris. They sued other adjacent landowners because Mr. Mosley's view is, I get a dock there. It doesn't matter if another one of my neighbors who has an equal right to use the right-of-way doesn't want a dock there. It doesn't matter if it creates an obstacle, right, for launching a boat. And now, if this court's going to seriously allow that, then where do you stop? How about a dock with a 90-degree angle in front of the right-of-way area? Why not? Right? Now, that clearly cuts off boat launch access. It clearly creates a problem. And if you put the dock in, why not tie up a boat to the dock?
What if two owners want to put in separate docks?
What if two owners want to put in separate docks? Exactly. What if you now have two owners with separate docks tying boats to each side of those docks? Well, aside from creating a de facto occupancy of my client's property, you've essentially cut off that access. We've got a 20-foot right-of-way. If you put a 4-foot dock even on one side of it, okay, you've taken up 20% of the right-of-way. If you put a 6-foot wide boat tied next to that right-of-way dock that you've placed there, now you've taken up half of the right-of-way. So there are real consequences to just saying, hey, as a matter of law, this right-of-way touches the water, we're going to allow a dock there.
Then it would follow they get a hoist.
It would follow they would get a hoist, sure. Why not a hoist? If we're going to extend this logic, why not take up the whole right-of-way easement? And then what do you do when somebody says, I just want to back my boat down, I don't want to have to navigate around a hoist, I don't want to navigate around a dock, I want to back my party barge down the more elevated section near the road, and I want to launch it. And I don't want to have to go through gymnastics and worry about arcing out on some sideways angle in an area where, again, there are topographical limitations. There are some rocks in there.
Counselor, I'm on the screen. Counselor, there's a big difference between if you're a homeowner and you have a dock in front of your house and then you can build whatever configuration you like in order to have your boats and your hoists, etc. But launch sites generally have like just a straight dock, and it could be as narrow as 3 feet in order to allow boats to come and go and people to enjoy the lake together.
Sure, I'm willing to concede that a common fact pattern in a straight shot right-of-way may include a dock. The two problems, though, with this, Your Honor. Problem number one, in this particular instance, my client doesn't want the dock there. Problem number two, in this particular instance, what exactly happens when a kid jumps off that dock and cracks his or her neck on the rocks? Who gets to absorb that liability? Is the argument that my client, the holder of the servient tenement, gets to absorb that liability because a dock was allowed to go in there despite the presence of rocks that created an obstacle? I would assert to you that,
Counselor, would it be any different if there was no dock and one of the 22 homeowners used the right-of-way as an ingress to the lake and dove in and did the same thing?
well, it may be, because in one instance, there's a structure that's being placed on the property. Now, admittedly, it's a structure that's placed on the property against our request if this court were to rule against us. But the existence of that structure, that tangible item that goes in at the end of that right-of-way creates a real problem, I think, in liability context as well, which I raised in my brief also. I mean, in sum, Your Honor, our primary argument is all of this is premature. We should be doing more of the depositions, and we have done some of those depositions. But setting that aside, I don't think this court can quickly just knee-jerk say, we're going to do Hush, we're going to do Holst. I implore the court to take a look at the actual right-of-way at issue here. Take a look at the photographs. Think about what the difficulties would be of backing a pontoon boat down that thing and trying to get it launched. And think about the issues of whether we should allow it.
Right now, in the condition of the property, you can't do that. With all the rocks and the trees, and they're alleging that your client has parked their vehicles in this right-of-way as well. I mean, you could not do that.
Well, I would respectfully submit there's a disagreement on that as well.
With the rocks and the overgrown grass, I've seen the photographs. I mean, there's no way you'd be able to back a pontoon boat down there in the condition as it exists today.
Sure. Judge Montour, respectfully, there are photographs in the record. This is correct. This is also a dirt run easement. It's a seasonal issue that happens with dirt run easements around lakes all around the state. When there's winter runoff and snowmelt, it creates rivulets that then create issues, and every year that has to be filled in and supported. But there are also photos in the record of the golf cart being driven down. If a golf cart can be driven down there, right, a boat can be driven down there. This is the whole other section that we're talking about, the obstacles section.
It's still 20 feet wide.
That's a whole other issue. It's 20 feet wide.
You're not talking about the golf cart limitation of the right-of-way of that width.
You have to, it's already difficult. I'll acknowledge it would be difficult. You'd have to back your truck in and get that thing down that narrow kind of channel before it opens up down by the
Someone
wall.
would have to maintain it in a certain respect before they start doing that.
Yes, and you know, I think
I don't think anyone's asking to do that, are they?
maintain it.
No, back a pontoon boat down.
No one is asking me to back a pontoon boat or my
I
client.
don't think any of the 22 owners are.
Not yet. What this court, what Mr. Bersani is asking for is a perpetual right that will run with each owner for all eternity to use that right of way as they see fit, and to expand on that. Once you get the dock, then there's the boat hoist.
Well, I guess his response would be each use, we would have to examine to see if it's incidental and reasonable to the use of that land. But your general point is that the trial court allowed discovery to continue on the way to trial. You think that process should continue and that these are issues of fact that should be resolved by a jury or a judge in a non-jury trial?
I do, Your Honor. Yes, and my disagreement with Mr. Bersani is I don't think as a matter of law, the court should simply be saying it touches the water, so you get an easement.
All right, thank you.
Thank you.
791, spine surgery of Buffalo Niagara versus Geico Casualty Company. Justice Montour is recused in this case.
May it please the court. Henry Nash of Rifkin Radler, attorney for Geico. For the third time, this court is forced to answer the same question. Can a medical services provider state a claim for prima facie tort based on the allegation that an auto insurer sent it duplicate NF3 forms? The answer was no twice before, and the answer is still no today. And there's two reasons for that. The first is that this fact pattern can't support an inference that Geico's sole motivation was disinterested malevolence. Now, plaintiff argues that Geico's motive can be inferred from the fact that Geico didn't retain any money from sending the forms and that the Geico continued to send them even though plaintiff informed Geico that there was a financial cost. But these are the same facts that were alleged in the previous two appeals. This court rejected those arguments twice before, and there's really no reason to revisit that holding today.
Has there been any developments with the Department of Financial Services? I know there have been complaints made. Previously, we've had a number of these cases. Is the Department of Financial Services still taking a hands-off approach?
Well, the Department of Financial Services in this appeal, in this record, indicated that there was no further action that was going to be taken. And there's I'm not aware of any further update.
You read that to mean that the Department of Financial Services perceived no violations of the no-fault regulations based on what Geico's been doing with NFT3 forms?
Correct.
All right, so in your view, this complaint, for all intents and purposes, is similar to the other ones that we've dismissed previously, and the same result should ensue here?
Correct. And not only for the disinterested malevolence piece, but also for the lack of
Special
specific damages. I mean,
There's a little more specific here than in the
That's
other
true.
one, but it's still, in your view, not enough.
That's right, because the time period is not specified, the number of forms isn't specified, and the number of claims aren't specified. And I would just close with one final point. The NF3 form actually specifically says, if you've submitted an earlier report on this accident, you only need to note changes from the information previously furnished and additional charges. And that's on page 75 of the record. So any harm that they've suffered from responding to these forms is self-inflicted.
Did I read their brief correctly that the provider has not been providing the information as requested in the duplicate NF3 forms that were requested by Geico, and yet the claims have still been paid?
Correct. And that's because the provider sends the information on a different form by fax. They send it on the HIC for 1500.
So if they ignore what they deem to be duplicate unnecessary NFT3 form requests, they are still getting paid by Geico?
Correct.
Okay, thank you.
You're welcome.
Good afternoon. Excuse me. Good afternoon, Your Honors. Dan Morris for the plaintiff appellant. I'll pick up where you left off, Judge Lindley. Ignoring the NF3s would resolve a portion of the damages. There is the notice given to the defendants that simply receiving the mail, even if these were not NF3s, there is a cost my client pays that the defendant was on notice to, and which was mentioned to them in a DFS complaint, and the same behavior persisted after the DFS.
So what do you make of the DFS not pursuing any action here? Are we to assume that they disagreed with your interpretation of the no-fault regulations, that it was not improper to send the multiple NFT forms for each treatment?
I would say that they took the misstatement of facts by the defendants in their letter in the record, which says that there was no mention of which dates of service my complaint was based on. The problem, of course, Your Honor, and that's clear in the record, is that the NF3 requests don't mention a specific date of service. It would be impossible to complete the NF3 form because the insurance carrier, in this case, is not requesting specific information. It's sending blank forms.
You concede that Geico has the right to send a new NFT form, a 3 form, for each and every treatment on the same patient. They're not limited to one at the beginning. They get one for each time the patient shows up. Your dispute is that when they request that, they need to be more specific in the date of the treatment and so forth.
I would say that they can only request information that they do not already have. In theory, Your Honor, what you're saying is that if they receive a bill, a completed HICFA, which is sent with a medical record for that date of service, which is quite literally all of the information the medical office has, for the insurance carrier to send an NF3 request, which is technically speaking a verification request, which would permit the insurance carrier to delay payment, for them to request information that they demonstrably and in the complaint and according to the facts of this case already have with the threat of delaying payment, that's an improper use of an NF3.
And you're saying that Geico is the only carrier in New York who is making use of these NF3 statements?
In this manner, yes. As the complaint states, other insurance carriers send them no more than once per patient, maybe once per date of service at the most.
But they're doing it to a lot of medical providers, not just your client.
Geico is, according to information alleged in the complaint, Geico is doing this statewide.
So how is that when we talk about sole motivation? They don't have anything against your client, they're doing it to everybody. Doesn't that undercut your prima facie tort?
I would say once my client informs them that every time he receives one of these, he is suffering a financial harm, and they persist, they do not get the information and still process the claim, which proves the uselessness of the forms, they are being disinterestedly malevolent. They simply don't care that my client is suffering the harm, and they persist in that behavior. I would also say, Your Honor, that the prior cases opposing counsel mentioned at the outset were disposed on, not on the merits. It was not a question of whether or not this theory can persist, but simply whether or not the complaint was specific
Right,
enough.
so let's talk about that.
Yes,
In the first action that was dismissed by Justice Montour,
yes.
we had the complaint in there. We agreed with him that it didn't state a sufficient cause of action. Then you recommenced it. What's different in this new complaint that wasn't in the old one? I know that Judge Panepinto, the paragraph she relied upon, which was 44, that was included word for word in the first complaint, which was 22 in the first complaint. The other allegations she relied on were 41 and 42. Those were 19 and 20 in the prior complaint, word for word. So what's new now on the missing element that we found that wasn't in the first complaint?
The list of claimants, injured parties and claim numbers, I believe over hundreds of them. That would provide Geico sufficient information to know that on those cases, on those claimants, that my client received spurious NF3s. And the reason we cannot...
But the argument is that what's missing here is that was the sole motivation.
The sole motivation
was to be malice toward your client. Where is that?
The malice towards my client is that my client informed them that they are being harmed every time a document is received. And that's claim by claim, patient by patient. After being noticed on an individual claim number that my client was suffering harm, the insurance carrier did not send a letter, did not send an apology, did not alter their course of behavior in any way. They sent in reply to a complaint that you're causing me pointless harm, you cause me the exact same pointless harm again, you are being malicious towards me. What's more, if you're trying to hold the fig leaf of an argument that we need this information and this information is necessary, then how were the claims processed without the information? What's more, all of the information was already in your possession. They can't have it both ways. They had the bill, they had the medical record, they sent documents. Whether they're a request for information or not is kind of irrelevant. And whether there was a regulatory violation, I would say is irrelevant also. Prima facie tort, no element of prima facie tort requires a regulatory violation. My client is protected from prima facie tort from regulated industries and unregulated industries. I would say also any allegation that there was an absence of a specific number of claims is because that list kept growing. The behavior persisted long before the DFS complaint and after the complaint was filed. This case is essentially growing larger every day, as is alleged in the complaint.
So what's been happening lately? The motion to dismiss was denied more than a year ago. Where are you in the proceedings?
We have not been able to proceed because we've been waiting for this. The judge has suspended discovery and all of those things.
Okay.
So we haven't been able to move the case forward an inch. I would, at a minimum, I think there is more than enough information alleged in the complaint for the defense not to be able to claim that they're surprised and that the specificity of damages is alleged to the degree possible considering the ongoing nature of the issues.
Thank you, counsel.
Thank you, Your Honor.
792 Merchants Preferred Insurance Company versus Junior Campbell.
Okay, good afternoon, Your Honors. May it please the court. Brian Barnes with Hurwitz Fine. We're here for the plaintiff and appellant, Merchants. Our position is the lower court made an error here when they ordered disclosure of certain materials from the claim file that were withheld in discovery. Now, if you look at the lower court's order, they did allow for certain documents to be withheld. I think it was 47 or so of the 174, 175 pages submitted to in-camera review. The lower court found that certain information about reserves and then certain information about value was properly withheld as material in anticipation of litigation. Our opinion is that that was too narrow. Our opinion was that there's no meaningful differentiation between the items that the court found were prepared in anticipation of litigation. We certainly agree that they were, right? We're certainly saying reserves should have properly been withheld, and we would submit that all notes about value should have been as well. But we don't think the court went far enough. And what I want to do is emphasize the difference between the case law that we're relying upon and the case law that Charlie, as the defendant, is relying upon here. The cases in New York are clear that a claim file prepared by an insurance company in the course of the defense of a lawsuit or a claim against its insured is material that's prepared in anticipation of litigation. I don't think anyone disputes that that's what the case law says. This department has found that numerous times in the past as well. The case law that Charlius is relying upon here speaks to a different situation. It's the general rule that an insurance company in its ordinary course of business investigates claims, and documents and file notes in the course of that are discoverable.
Counsel, this is a different situation, isn't it? This isn't just a plaintiff versus a defendant who's insured. You're in a position now of possibly being able to not defend your client because of some significant communication problems. And I think some of that discovery that the plaintiff was looking for was related to those kind of communication problems. They'd like to solve those problems, or they'd like to be able to figure out whether those problems were in fact, problems, okay? Because there are lots at stake, being able to, succeed in their lawsuits at stake, okay? And they probably don't care about your defenses to the actual incident giving rise to your coverage. What they're trying to figure out now, from what I can understand, is what you've done to be able to get that coverage in place, or what you haven't done to be able to find your client and get your client to cooperate.
Sure, and the point I want to make in response to that, Judge Bannister, is we're not submitting that they're not entitled to that information, right? I'm not standing before the court and saying they're not entitled to our information that we looked at to try to obtain our insured's cooperation in the defense of the underlying action. If you look at our privilege log, if you look at the in-camera documents, and we submitted them as a confidential record to the court with the redactions marked on what we had redacted, we have turned over the documents that demonstrate our efforts to get our insureds to cooperate with the defense. And we're not taking the position that they're not entitled to that. The position we're taking is the other stuff that's in there.
It seems like what they're looking for primarily is evidence on the issue of the timeliness of the disclaimer. That would seem to be the main issue here, and they want to look at some of the records for that issue.
So I'll make 2 points about that. The first one is that the documents that we've turned over all speak to that, right? Any efforts by merchants to try to obtain its insured's cooperation necessarily goes to when merchants would have known it was able to disclaim for non-cooperation.
So you're saying they have all of that?
I'm saying they have it. And I think if you look at the in-camera documents we've submitted in the privilege log, it speaks to that. The second point I'll make is it's a 3420 argument, right? The brief cites 3420, and we go into our brief about the standard for non-cooperation. What we should have gone into in more detail is this is a Florida accident. If you look at the language of insurance law 3420D2, it provides that the timely disclaimer requirement contained in the statute only applies to accidents that take place within the state of New York. This is a Florida underlying accident. Our position is that New York law applies to this dispute if you do a choice of law analysis, which is not briefed and will be an issue once we eventually get past this discovery dispute and get to summary judgment. But our position is that the timely disclaimer requirement of 3420 doesn't apply. Now, I'm not saying that in the sense that they're not entitled to our information about our investigation into the cooperation issue. Again, my position is we've turned that over. They can't demonstrate a need to get past the material in anticipation of litigation privilege in this case for the other stuff in the claim file. This is the plaintiff in the underlying action. I understand that it presents a bit of an interesting situation where merchants here is trying to disclaim coverage to its insureds for this lawsuit. But that does not mean that the insureds have waived the privilege for the communications that concern their defense. It's not my privilege to waive, it's the insureds. The insureds haven't appeared in this action, they're in default, but I can't turn over the documents from the defense of the insured in this case, absent some substantial justification, and I would submit to the court that that is not on the record here.
All right, thank you, counsel.
Thank you, Your Honor.
Good morning, Mr. Myers.
Good afternoon, Your Honor, I think.
Correct.
This is a rear-ended accident. And we believe the liability on this, from a liability standpoint, is
But
really...
that isn't before us.
I understand.
We have just a discovery dispute as to what you're entitled to
That
and
is
what
correct.
you are not.
That is correct, Your Honor. That's correct. But the timeliness notice in terms of the accident, 3420, we believe is an issue.
Okay, and they just told us that they
They
turned
agree
over
with you.
everything that they have in regard to that issue.
Well, I submit that they probably have not. I've not seen the document, so I don't know what they have withheld.
Right, you're arguing blind, but we're not deciding blind, because we can look at that.
That's correct. That's correct. That's correct. And first of all, what I would say is, what the law is in terms of disclosure in these types of case is that their contention that any notes that were prepared in anticipation of litigation is privileged. But I don't think that's the case law here. And I think we have cited the cases that anything before they make the determination in terms of disclaiming of coverage, any claim notes, any investigative reports, any even reports in terms of attorneys, this is in fact discoverable under New York law.
So if it's about the value of the case, or
I don't care about the value of the case per se.
if it's about the defense strategy,
Well,
why would you be entitled to that if the issue is whether their clients have cooperated or not? Your issue is they haven't timely disclosed that. You want to know what efforts they made to contact their client. What difference does it make in that litigation about what their defense strategy is, or how injured your client is, or what they know about her prior condition?
Because if in fact their investigation in regards to the liability of it, and if in fact they determined relatively early on that they were not getting the cooperation, and if the reports are focused on the fact that that the liability is very clear cut, I think this supports our arguments in regards to the lack of proper notification.
And they say anything that deals with notification and their attempts to reach their client, they've given you. And you can't say that isn't true. You just don't know.
I just don't know.
And you say, let me see stuff that they don't want to give me. And after I look at it, then I'll decide whether they complied or not.
No, I don't say this, because what I said to the lower court is do an in-camera review. And this is exactly what the court ordered. And the lower court did that. And the lower court made the determination. And generally speaking, in terms of disclosure dispute, unless there's an abuse of discretion, this court usually supports whatever the lower
But you
court
understand,
decides.
we have to look at the files and the
Yes.
evidence ourselves to see if we agree with the trial judge, is her determination item by item. So that's what we're going to have to do. We understand your argument, though.
Yes, but I also, in terms of his statement, in terms of the broadness of what they claim in terms of privilege in these types of situations, I submit to you that we are entitled to anything that may reflect or could be supportive in terms of us. Otherwise, we're going, when we make the motion that's going to be made by both parties in regards to this case, the record would not be complete.
Thank you, Counsel.
Thank you.
Case 794.1, Hallaby versus Denzek.
Good morning, Your Honor. Frank Alloy for Samuel Hallaby. With regard to the direct appeal of Mr. Hallaby, the only issue for the court is whether the trial court was correct in refusing to grant Mr. Hallaby an injunction for the removal of the fenced, raised garden on the next door property in the natural buffer area.
So your client won on the shed but lost on the fence?
Yes.
He won on the, now, so we
On
have,
the merits, Judge, he didn't lose on the fence. The court said that the raised vegetable garden enclosed by the fence
did violate.
was a violation.
Right.
It boiled down to whether Mr. Hallaby, for some other reason, could not assert a successful claim for an injunction for removal.
So you're here, you got half a loaf, your client wants the whole loaf.
That's correct, and he's entitled to the whole loaf because...
Why don't you talk about, because I think Mr. Hartzell's arguing that his client wants the shed and that the judge got it wrong on the shed. Why don't we just briefly touch on that issue? Then we can move to the fence before we give Mr. Hartzell a chance.
With regard to the other matters that are basically in the cross appeal at this point, the general purpose of these uniform restrictions indicates that this is supposed to be forevermore a fine suburban residential development. They're going to promote this, and it's for the benefit of all the ownership people who are part of the, who own all of these properties. Actually, 8 of them on Tennyson Way and 2 kind of around the corner. The restrictions indicate that the only structure to be on the property is a single-family dwelling.
But then it goes into section 6 where it talks about no structure such as steel tool sheds, lean-tos, or mini barns, except pool cabanas and/or gazebos, or other such structures as may be permitted by the developer who's no longer around. So that's what we're fighting over. That's what the dispute is over. No structures such as steel tool sheds and so forth. So does this wooden shed, we'll call it, is that permitted under that language?
It is not permitted.
And why
It's a
not?
violation of the restrictions.
It says
There's no question.
steel, it says no structures such as steel tool shed. So I guess why wouldn't wooden sheds then be permitted?
Because what Mr. Hallaby purchased, among other things, was the pastoral setting, the aesthetic setting for his high-end home. Sheds 10 feet from his lot line, they are just way beyond the general purpose of the subdivision. This is not...
Counsel, looking at the language, though, it specifically says steel tool sheds. It doesn't say sheds
Screen.
aren't permitted. It says
Screen.
steel tool sheds.
She's on the screen.
Oh, I'm
Right in
sorry.
front of you, right there.
I'm appearing virtual, sir. Sorry.
Again, single-family, high-end residences. Sheds,
Counselor, have you ever seen a she shed? They're pretty high end.
excuse me, say again, please.
You know, this agreement was signed in 1992. Ever since, I don't know, 2015, sheds have gone way up in the world in terms of architectural design.
Well, Your Honor, if you took a look at what these houses look like, and of course,
I saw the
bunch of
picture.
pictures. Yeah, there's a bunch of pictures in the record. There's no question that these sheds just are absolutely anathema to what this high-end residential
But it's
subdivision
not
is all
what-
about.
It's not what the restriction says. The restriction says there shall not be steel sheds. So you're entitled to say, well, if it says steel sheds, I'm just going to apply it to wooden sheds, everything else. But it doesn't say it.
What it does say is fine residential development in order to promote and provide collective individual ownership benefits. That is part of what Mr. Pallaby put money on the table to get his house.
Right, he didn't want anything there, but I think what your argument in the brief was, and below the argument was the words, no structure such as steel tool sheds. You placed emphasis on such as, meaning we're not limited to steel sheds.
That's correct.
That it's just such as, that for an example, this is one thing that's not permitted. That's not the only thing that's not permitted in the general tenor of that provision. Look, this was not written very well. And it could have been written a lot clearer. Nobody really knows what was intended here, but that was your argument below. Such as doesn't limit you to stool, doesn't say that that's the only thing you can't build.
That's
And
correct.
that wooden sheds are similar, but Mr. Hartzell argues this point that at the end, there's an exception. It says, except pool, cabanas, and gazebos, and other such structures as may be permitted by the developer. The developer dissolved in, 1996 or something.
Correct.
So Mr. Hartzell argues it's not fair to all these other homeowners. They've been deprived of their ability to get permission. There's no one to get permission from. Therefore, it shouldn't be enforced at all, as I understand his argument. What do you say to that?
Well, there is no procedure in the uniform restrictions for a variance. That is correct. But again, I have to come back to the pastoral environment. I have to come back to the aesthetic environment. I have to come back to what my client looks like when he gets up in the morning and looks out his backyard or looks next door to the other house. It's kind of visual pollution, this stuff.
Right.
And
When your
it's-
client bought, this was not his expectation.
No,
to
I
have
mean, this is-
stuff. So we understand.
And the other thing also is that the Stover case has much analysis about aesthetic issues being actionable. And, you know, I spent a lot of time working through Stover and looking at cases in different jurisdictions and all the rest of it. And it's good law in this state. And I just don't see that urban farming, so to speak, you know, with raised vegetable gardens, sheds 10 feet off the lot line for one of these fine architectural houses. It just doesn't make any sense. And it's beyond what was intended by the developer.
We understand. Thank you.
Good afternoon, Your Honors. May it please the court, Tom Hartzell appearing for the defendant Denzax. I guess I'd first say, and I will get to the shed issue because I see the court is interested in that one. I want to remind all of us what we all know, which is that New York law, public policy, favors the free use of our land. And so, therefore, any restrictions on that free use of the land must be strictly construed against the person seeking enforcement. Here, the language in the restrictions, in the Uniform Plan of Restrictions relating to the sheds, which is Section 6, and also with respect to the garden, which would be Section 1, and the fence, which would be Section 2, I submit that the language in those sections is all ambiguous, capable of several different interpretations, and hence it's too vague to be enforced when New York promotes free use of your land. It's not specific enough.
Sounds like it hasn't been enforced anywhere else in the subdivision.
And that's right, Your Honor. There's 10 residents in this neighborhood, and 4 of them, so if we don't count my clients, 4 of them have sheds and also have gardens and fences on the north side.
But on the other hand, Mr. Hallaby's point is, they're not in my visual sight of line. It doesn't matter to me what they do over there. What matters is Mr. Denzack is his neighbor, so he would have objected if those polluted his view, I guess is the way he would put it.
Fair enough, Your Honor. I mean, I understand that point. However, what Mr. Hallaby bargained for, just like what my clients, the Denzacks, bargained for, were what's in those ambiguous restrictions. which is not the sheds that are prohibited, and the court's right, it should be clearer. It says steel tool sheds are an example of a prohibited object. It could have said sheds. It could have said tool sheds. It would be very easy to say that. It didn't say that. That implies that non-steel tool sheds are permitted.
What about the overall aesthetic that the council is arguing that the shed that's next to him doesn't fit in with the high-end pastoral setting?
I think it's false, Judge, respectfully. I think that argument is misleading because actually the argument here is Mr. Halby wants to have this great aesthetic and this high-end suburban neighborhood. Well, if we look at the spirit of the restrictions, it's still provided for with an architecture. He still gets that, what he bargained for, with an architecturally compatible non-steel shed that's in the woods.
Is the arbiter having somebody to say, yes, that goes with the neighborhood, that doesn't go with the neighborhood?
I'm sorry, Judge.
The arbiter.
Who is the arbiter?
Well, it was supposed to be the
Right.
builder. So are we just giving up the idea that there is an arbiter that says, yes, this is within the thoughts that the neighborhood would look this way? You know.
The arbiter is gone, you're correct, Judge, and so what we submit and argue is that, especially in light of the fact that the restriction should be strictly construed, if there's going to be a burden restricting other structures, it's balanced by the benefit, and the benefit is to be able to get permission. So without that benefit, equity requires that the burden be extinguished.
Right, so your view is that it's too vague to be enforced, and also there's no, the developer's gone, so there's no one to grant permission, so there should be no restrictions whatsoever.
Well,
people could build massive garage, massive barns. There's no restrictions whatsoever. That wouldn't seem to be in the spirit of the subdivision at the beginning. As council said, it said no structure shall be built except for single-family homes. That wouldn't seem to be consistent with that.
Agreed, Judge, and we're not advancing that argument. We are saying that these restrictions, because yes, Section 1, no other structures, it says, but Section 6 it does say there are other structures allowed. Since we don't have that method of getting permission, if the argument that non-steel tool sheds should be allowed anyway, we don't even need to get to the permission argument. But if we get to that permission argument, that balancing is not there, and other structures, no. It shouldn't be that any structure is permitted, no. We're asking that just the language, the ambiguous language, be extinguished, and that actually the court revise the language as set forth in our brief, which is page 69 of our brief. And that is just, it should just say no steel tool sheds, for example, and et cetera. You know, it should not have this ambiguous language. And that's true with respect to the garden and the fence too. That language should be modified, extinguished to the extent that it is ambiguous and unclear. It can easily be made clear for the benefit of all the neighbors, many of whom already have sheds and gardens, and to avoid future litigation by extinguishing that language, revising it as we've set forth in our brief.
All right. Thank you, Mr. Hudson.
Thank you, Judge. Thank you.
You know, we'll be back. We got a couple of us who we have to recuse. We're going to get a new panel.
It's a different configuration.
The last case on for argument is case 794.2, Galloway versus Holdsworth.
Good afternoon,
Counsel?
Your Honors.
Proceed.
Brittany Permuthy appearing on behalf of appellant here. May it please the court. Here, appellant seeks to invalidate the nomination of a candidate by a committee without the authority to so nominate and without a properly and duly noticed meeting. Let me begin by noting the petitioner here is a duly enrolled Republican, or of the Republican Party, requesting that the party follow their own rules and election law. At issue is a vacancy in Buffalo City Court, a subdivision within Erie County. Respondent, Republican Committee of Erie County, had the express and only authority to make a nomination for this vacancy, as indicated in their own rules. Turning to Article 5, Paragraph 2, page 57 of the record, Your Honors. Respondents are quick to ignore the part of the county rules, instead arguing the city chapter has its own rules on nominations, and so let's just follow the city rules. But what's very important here is the significance of Article 5. Article 5 indicates in paragraph 2, and I quote, "Additionally, the executive committee of the county committee shall be empowered to authorize the designation or nomination of any candidate pursuant to the provisions of Article 6 of election law for any office to be filled by the electors of any district or subdivision wholly within Erie County."
And you say that applies to the city of Buffalo?
It absolutely does.
Absolutely. I agree with you that the Erie County Republican Committee had the right to do this. But if the Erie County Republican Committee rules delegate that to a duly elected subcommittee that represents just the city of Buffalo, what right do you have to challenge the Republican Party, the Republican Counties Committee delegation of that role to the Republican City Committee?
I would say that if they were to so delegate or divest that authority, that could be done and I couldn't challenge. But there was no divestiture of, in fact, the power to so nominate. In fact, if you turn to then Article 2, if we're looking at, and that is of page 52, Article 2, Section 1, it says that those lower subdivisions of the Republican Party certainly can make up their own rules, but they can't be in contradiction to the county rules, and it can only be that of which is divested from the county.
But then what do you do with matter of Rolls versus Orsini?
I think that's actually distinguishable, Your Honor. I think in Rolls versus Orsini, there was no explicit county rule that said nominations were to be done by the county committee. And because there was no rule at the county level, of course a local committee had the power to create a rule because it wasn't in contradiction of the county. But here, that is not the case. Here, there is very specifically a county rule that says this county has the express and only power to make all nominations of all sorts as long as it is totally within the county. And that is what is here. The city of Buffalo, is completely within the county of Erie. So Article 5 of the county rules dictates that it's the county that is going to so be empowered to make the nomination. Now,
Can you read these two sections together? In other words, can you say that, yes, the county does have authority, and within the confines of the rules, they provided for the city to do it in this instance within the city of Buffalo? And how are they in conflict with each other? And if they're not, shouldn't we read them as being harmonious?
no, Your Honor, respectfully, I do believe that the county it will always, according to its rules, retain the power. The county then, according to Article 5, Paragraph 4, the county may decide at any point, the executive committee of the county may decide they can delegate that decision, nomination, what have you, designation, to another subcommittee or a local committee. Or in fact, the secretary, I believe, of the county committee and the chairman can be the total two that just decides who that nomination is.
But I think you're reading Rowles versus Orsini incorrectly, because it seems there the court held, when they were talking about it, here the rules of the party, and that's the county party, do not provide for such other committees. And therefore, they went beyond it. If what you were asserting was the law, then they would have said, since the county rules don't allow such other committees, the county committee alone can make the determination. The court actually held the exact opposite. They said, although there's no county rule that permits the towns, we're saying only the towns get to make the nomination because they were the last duly elected subcommittee covered by this region at the last election. So I don't understand your argument in light of our precedent.
My interpretation is that the county would have to explicitly delineate that I'm retaining this power to make that. Because otherwise, turning to Election Law 6-116, it is in fact, it could be the county committee, it could be a local committee, or it can be any committee the party so delegates. So I do think in following the Rolls versus Orsini, they were saying, well, look, in accordance with election law, it is in fact not a power that the county has retained, and because the county hasn't retained that power, the local committee certainly under the election law has that power. But that's different than here, because here, under Article 5, it is the county committee that has the power. And it's important to look at Article 5 and not the city committee rules, because in fact, if you look very specifically at the nomination that was filed here, that nomination says it was filed in accordance with Article 5 of the county committee. I mean, that's very specific, that is in fact what that certificate of nomination states. It doesn't say that the City of Buffalo local party made this nomination. In fact, it says, at a meeting of the members of the Republican County Committee of Erie County, the county committee, last elected. Now it goes on to say, in the political subdivision in which such vacancy is to be filled, being the committee designated by statute. But then it says, and Article 5 of the rules of the Republican County Committee. So we turn to Article 5, and Article 5, in fact, very much states that it is the county committee that retains the complete control to make all nomination designations herein. So it is the county committee that has the power. The county committee, like Your Honor Whalen had said, can certainly delegate if they wish or divest that power to anybody else. That was not done here. In fact, the city local committee concedes, no, we have the authority per our local rules to make the nomination, so that's what we're going to do.
And that the local rules are authorized by the Erie County Republican Committee.
I disagree respectfully, Your Honor. I think that, in fact, there's no delegation of that power to the local committee. Article 5 does not say that we're divesting that power to the local committees. If that were the case, Your Honor, we could have very much some rogue local committees that just decide to nominate whomever they wish, Republican or not. That's why, turning to, this court's very ruling in the Danielwich versus Argima, I'm sorry if I mispronounce it. That's a Fourth Department decision, though. And that Fourth Department decision was explaining that it's the county rules that kind of dictates how a county party and its local subdivisions are to be run. And here it's the same argument. Turning to Gracer versus Cohen, obviously this is an older case from 1937.
Counsel, isn't this purely a battle internal to the Republican Committee? This is not where you're trying to enforce the rights of the Erie County Republican Committee, that if what you say is true, they have no interest in enforcing. They are content, and so state an affidavit from the Erie County Republican Committee chair that they are content and intended the city committee to make the nomination. What right does any individual Republican get to challenge the internal workings of the Republican County Committee and its appropriate subcommittees?
I would argue, Your Honor, that being a duly enrolled member of the Republican Party, they have standing under election law to simply contest what is being done by their party. It would be different if this were a Democrat or an independent or a blank. Obviously, they would not have standing. But here, Petitioner Galloway is very much a Republican, asking that his party obviously follow their own rules in making nominations. And that was not done here. To say that it's internal, I completely disagree with. This, in fact, is an argument of just following the election law, following the rules. Election law, again, 6-116, dictates it is the county or the local committee or as the rules so prescribe. The rules were not followed here. The rules dictated one thing, and that just simply wasn't done. And this court, I think, should respectfully and should invalidate the, obviously, nomination and strike candidate Holdsworth from the petition. She was not properly nominated. It would have had it been by the county. We know it wasn't done by the county. Even turning to the meeting argument, if I may.
The what argument?
The meeting notice argument. Whether you want to say it's the county or the local committee, our argument or our position is that a meeting was not duly or properly noticed so that a nomination could be made. In that, we obviously have to contest that based upon information and belief, because Petitioner Galloway is not in fact a executive member of either the local Buffalo City Court Committee or the county committee.
So no one who's entitled to notice is claiming they didn't get timely notice.
That is correct. But our position is that there's nothing, we made the allegation, we believe we're entitled under election law to a hearing on that very issue. Prove to us that in fact this meeting was properly held, because our contention is it was not.
So there's no threshold showing that you have to make. You can just allege out of curiosity. You can say, I have no idea whether notice was given or not, but I'm going to say it, and now you got to prove it.
I think you could do it upon information and belief. If you have a reasonable cause to believe that the meeting did not occur. Remember, in this instance, at first we thought it was actually the Republican Executive Committee. So, because if you simply look at the certificate of nomination that was so filed, there's nothing in that certificate that specifically delineates it was the local City of Buffalo party that nominated. So originally, the petitioner's contention is, well, wait a minute, I'm pretty sure the Executive Committee of the county did not meet to make this nomination, which we now know did not occur. But it was pled such that, look, whatever it was, whatever committee of the Republican Party, this was not done properly. This was not, in fact, a meeting that was duly noticed. So our position is that a hearing should have been held by this court. But we would also argue, I don't even know now if a hearing is necessary, because in fact, when on the verified petition, we made that argument, no notice or no meeting was properly held, that was not, in fact, a position that was contested by the respondents. I think it's quizzical. The response by the respondents was, well, that's a matter for the court to decide, in so many words. And so there was no outright denial that a meeting was not properly noticed. It was, let the court decide that. And of course, the court did make a decision, but it wasn't after a hearing. The court didn't hear any facts contesting what it is that petitioner put forth, that a meeting was not properly held. And I think that omission or lack of a rebuttal of any sort to the allegation a meeting wasn't properly held requires this court to accept that in fact a meeting was not properly held.
I think we have that argument, counsel. Anything further?
If I just very briefly may. It's important, I think, here, Your Honor, especially Justice Nemore, that in respondent's brief, there is not a single case that is ever cited in respondent's brief to support their position that the local party is in fact so empowered. Not a single one. There are, I think, 16 cases cited by respondents. Those cases sites don't begin until page 13. There is not a single case respondents cite to in their response papers or in this respondent's brief that ever supports the position what was done here was appropriate. I think this court should very much invalidate that petition of the certificate of nomination, strike her name from the ballot, and again, just one more very briefly. The argument about impossibility at this point or at this juncture is just pure falsity. Certainly it's as if,
They just cannot count the votes. Who cares?
It's a nullity, right? It's a nullity.
The day of the election, who cares?
I don't want to be so grim, but it's much like if a candidate were to pass away, right? Those, votes on that particular Republican line are just a nullity. So, and not to mention, there's not even proof anywhere before your honors, or that I'm aware of, that ballots can't be reprinted for the, early voting or for the general election. And here, certainly, this candidate isn't precluded from running. I must note, this candidate can run a write-in campaign, as your honors are all aware, was done very successfully for Mayor Brown. So there's nothing that's precluding or disenfranchising voters from casting their vote for candidate Holdsworth. By all means, do it. But it can't be on the Republican lines because there were rules and election laws that need to be followed, and it simply was not done here.
I think we have that, counsel.
Thank you, your honors.
Thank you.